Thank you very much. We may be seated. We are gathered today as we are commemorating Nelson Mandela Month, and on Sunday, on the 18th, we all know that it was Nelson Mandela Day. As the Department of Justice and Constitutional Development, we deemed it necessary that part of us giving back to our constituency, which is yourself, legal students, is to guide you and assist you as you embark on this very interesting career. We often refer to Tata Madiba as the advocate for human rights, and we hope that you will carry out his legacy of advancing human rights, the culture of human rights, and living to the constitutional values. So I'm going to request that the Acting Dean of Faculty of Law, Prof Juanita Pienaar, to come and officially welcome us. Over to you, ma'am.
Good morning, everyone. I'm Juanita Pienaar. I'm the Acting Dean of the Faculty of Law, and it is my absolute privilege and honor to welcome you all here at this very special gathering. A special word of welcome to our Deputy Minister, Minister Andries Nel, and staff, Justice Nuku, Western Cape High Court, actually a very familiar face in Stellenbosch, and then of course our own Professor Thuli Madonsela from the Centre for Social Justice. Welcome to the representatives of the LPC and the Cape Bar Council, colleagues from practice, and of course our students and Stellenbosch University representatives. And when I say our students, I don't only mean Stellenbosch students, I mean everyone here. Public universities, our sister universities, but also private institutions. We are very honored that the Department of Justice and Constitutional Development has partnered with the Faculty of Law and the University to host a Career Day for law students here, forming part of the department's commemoration of Mandela Month. We are meeting here today in this venue instead of the Faculty of Law because classes have resumed this morning and the campus is abuzz. And I'm happy to say when I left the faculty, students were actually in class. While not on campus, this venue is just one block from the very unique Madiba statue in front of the town hall. So in this context, the venue is perfect. It's at the center of town with Madiba keeping an eye on us. This year's theme is the Constitution at 30, preserving Nelson Mandela's legacy of equality and justice. In this commemoration, we all have an integral role to play. We as educators of law students, but everyone here as well, the department and its officials, members of judiciary, legal practitioners, professional bodies, Chapter 9 institutions, and government legal professionals. Also present here today are our students and our student leaders, our future, the next generation to whom the baton is passed, tasked with safeguarding the legacy of equality and justice. It is critical that the work continues. Sadly, 3 decades into a constitutional democracy, South Africa has remained one of the most unequal societies in the world, still grappling with economical, educational, housing, and health challenges. At the Criminal Justice Colloquium held at the Faculty of Law last week, 16 and 17 July, Professor P.J. Swikart, Emeritus Professor of UCT and world-renowned scholar, identified 3 major concerns threatening the legal order and the efficacy of the South African criminal justice system. These included the perceived absence of legitimacy of the system, constitutional skepticism, and inequality. The latter is especially pertinent in the current atmosphere and, of course, in celebrating Nelson Mandela's legacy. The best constitution in the world, with the best legal scholars and judiciary, would still struggle to advance justice in society where such glaring inequality persists. In her keynote address, Professor Schwickart advocated for the reimagining of a criminal justice system from the perspective of Ubuntu values. This morning, I would like to add something to her call. This morning, I urge all of us to take responsibility for continuing Madiba's legacy. Every one of us has a role to play in redressing inequality and advancing justice. A gathering like today, a career day in close collaboration with government, with a broad spectrum of the legal profession involved, our academia and our students, under the watchful eye of Madiba, seems a step in the right direction. May today and the other initiatives linked to Mandela Month recenter our focus on what really matters. May today bear the necessary fruits for all of us, for this generation, but also for generations to come. I hope you have a wonderful morning here in Stellenbosch.
Thank you very much, Prof. I think we do feel welcome and we all can relax and we're all gonna have very interesting conversations. Just a few housekeeping. May I kindly request that we put our cell phones on silent mode or on vibrating mode. The bathrooms are behind you. One of the ushers will show you where the bathrooms are. I am not going to waste time. You know, for the first time, we're gonna stick to time and we're gonna open up for robust engagements. We're not going to steal on your time. I'm going to introduce our Deputy Minister, Deputy Minister Andries Nel. The Honorable Andries Nel, MP, is the Deputy Minister.
Yeah.
You don't need that.
No, I don't need that. And in fact, I'm going to talk a little bit about that when I talk.
You introduce.
So, thank you very much.
Thank you, Tshepo.
Thank you very much, Program Director, Ms. Topsy Musi, and my apologies for the somewhat rude intervention that I made in your program directing duties. And first of all, just a very, very good morning to everyone. And thank you so much for the opportunity to be part of such a vibrant and energy-filled event. I mean, the moment I even started getting close, I was hearing that something is happening here, and it's something good that is happening here. I don't want to do the thing that we all do, but which we all inwardly, when we hear other people do it, we say, oh, but is this the fourth person who's greeting everyone? But I think this morning it is indeed a real pleasure to greet and to acknowledge people. And it's not just a formality, but I think it is also important that we recognize those who are amongst us, but also those who will be playing a particular and an important role. I think firstly, it's just a great pleasure always to be with Professor Thuli Madonsela, someone with whom I've walked a very, very long journey, both before 1994 in the formative years of drafting our Constitution, and I think just equally, if not more important, the road that followed after that, in her tenure as public protector, but also more recently in the academic world. I think also a great pleasure to be with Professor Juanita Pienaar, and also appreciating the great expertise that she brings both academically, but also participating very actively in important parts of our national discourse, in particular around issues of land. Professor Tshepo Madlingozi, also playing a very, very important role in the South African Human Rights Commission. I'm very, very thankful that we have with us Judge Lister Nuku from the Western Cape Division of the High Court. When I recently spoke at a similar function at the University of Northwest, that was one dimension of legal practice that we didn't have with us, and that's the judiciary. From the Cape Bar, Advocate Fiona Gordon-Turner and her somewhat counterpart in government, the Acting Solicitor General, Mr. Felix Mbeki. Also the Director of the Western Cape Legal Practice Council, Ms. Karen Jivan, and Mr. Makubele Mukulubete, a Chief Director in the Department of Justice and Constitutional Development. He does a lot of work on legislative drafting. I don't want to make any assumptions or make any suggestions, but I too once was a student, and I know he at the moment is busy, hard at work in drafting the regulations which will make it possible for the President to sign the entry into force of the Cannabis for Private Use Act. So we also have the Assistant Master of the High Court, Ms. Amanda Anthony, and I think it's very, very important because generally we associate law and the practice of law with appearing in courts, but the Master's Office is such a vital, vital element of our justice system, and it is one that the Minister and I, out of all of the emails that we receive requesting assistance and also often conveying very heart-rending complaints, revolves around the work of the Master's Office. So any of you who want to come out and help there, you are most welcome. Mr. Pumezo Qelile of Legal Aid South Africa, another vital, vital element of our legal system, which I'll talk about later. Advocate Renee Eis, Shanaz Nordin, and Vincent Keche of the National Prosecuting Authority, Mr. Kolani Nyali from Bowman's Attorneys, Nzimasi Mayeza from Nkohla Attorneys, Ms. Tanisha Vaswani from ENS. I can see the big five are well represented. Representatives of law firms, representatives of the Western Cape Office of the Public Protector, Mr. Rodney Isaacs, the provincial head of the Department of Justice. As I said, I've done those acknowledgements not for the sake of formality, but I do think they give us a very clear sense of the breadth of what constitutes legal practice. And I'm very, very happy that they will all be, in their different ways, sharing that. Maybe just before I start, I want to now come back to what I so rudely interrupted Ms. Musi on. And that is just to say something about myself, and that's not for the pleasure of talking about myself, but to illustrate certain points around the law, life, and struggle. I was born in 1965. I was born in New Orleans in the United States because my parents were South African diplomats. I then proceeded to live around the world. 4 years in Taiwan, after that about a year and a half, 2 years in Mozambique, in a very interesting historical time period from 1974 to around close to 1976. It was the time that Mozambique had just started the transition from colonialism to independence. And seeing a country make that transition had a very, very profound impact on me. Returning to South Africa just in time to experience very distantly the 1976 uprising. Watching scenes on television, which was then still very new in South Africa, being assembled in drill formation at school and being told about the riots and how we need to be prepared, being assembled to write letters to soldiers on the border, and then leaving apartheid South Africa for São Paulo, Brazil, and arriving in a country where at first glance there was no apartheid. There were no laws that prohibited people from living in the same area, studying in the same schools, from falling in love and getting married. But at the same time, it didn't take me long to realize that Brazil was a profoundly racist society. The school that I went to, the number of black children I studied with, I could count on the fingers of a hand. The social club to which my parents were given honorary membership had no black members whatsoever. In fact, later I read that even during apartheid, there were more black university students in South Africa than in Brazil. And yet Brazil is vaunted internationally as a racial democracy, a big mixture where everyone lives happily together. But that's not the case. And I think for me it made a very profound impression that even when one succeeds in politically overthrowing an unjust system, the consequences and the social reality can live long after you've done away with the laws. And I think that's a lesson that prepared me well for returning to South Africa, which I did in 1984. Let me just also say that Brazil at that time was under a military dictatorship, also starting a transition to democracy. I first became politically active at high school, organized fellow students in protest against the dictatorship which was still in place. It was the time of Luiz Inácio Lula da Silva, who's now the president of Brazil. At that time he was a trade union leader and later one of those who formed the Workers' Party. When I returned to South Africa, it was shortly after the introduction of the tricameral parliament, in response to which also the people of South Africa came together in various organizations, including the United Democratic Front, the UDF, which was an umbrella body which brought together about 400 organizations, civic organizations, women's organizations, trade unions, youth organizations, cultural organizations, sporting organizations, under the slogan, "Apartheid divides, UDF unites." And at that time, I belonged to what later became known as the Young Lions of the 1980s. And we responded to the call by the then ANC President Oliver Tambo in a January the 8th statement of 1985 to render apartheid ungovernable. And those protests spread throughout the country. People were organized in those civic and youth formations. And increasingly the regime found it difficult to control those protests. It culminated with the assassination of the Cradock Four and a massive, massive funeral. After which the regime declared a state of emergency. I remember it was a university holiday. I was studying at UCT at the time, and I caught a train in Pretoria. And as my father saw me off, he just said, "My child, be careful, there's something big coming." By the time I reached Germiston, I watched the 8 o'clock news and I saw P.W. Botha declaring the state of emergency. By the time I arrived in Cape Town, tens of thousands of people had been detained without trial, including many of my own fellow students, comrades. I still wonder to this day whether, if I hadn't been on the train, I would have gone in with them. Newspapers were banned, organizations were restricted. And that made me also reflect, because at that stage at UCT, I was studying philosophy and mathematics and some social science, because my great desire in life was to develop a scientific understanding of society, to bring together the elements of natural sciences and social sciences, something which I'm still very interested in and still devote quite a lot of time reading and thinking and writing about. But at that point, I reflected and said, is this the skill set that is most immediately needed? And it was in that context that I then decided to change and study law, because I thought these were skills that could make a difference in the struggle against apartheid. I went and started studying law at University of Pretoria. We continued organizing. At Stellenbosch at that time, progressive students organized themselves under the banner of the National Union of South African Students, NUSAS. We tried to do the same at Pretoria, but we weren't allowed to. So we created another organization called Studente vir 'n Demokratiese Samelewing, SDS. There is someone here in the audience, Haneli Boyens, who was one of those students. We started off as a group of probably not more than 12 students. By the time we reached 1990, we had grown to about 200 or more. It was a time when many, many young white South Africans were also starting to introspect and to ask themselves whether that was the kind of society that they wanted to grow up in, work, and continue living. Many of us as young white men were eligible to be conscripted into the military for 2 years, very often sent to the border, but at that time increasingly into black townships of our country. And we said, no, we refuse to serve in an army that is oppressing our fellow students. Towards 1990, I started working at an organization called Lawyers for Human Rights. I focused on death penalty and prison reform work. At that time, there were still hundreds of people on death row. When former President de Klerk unbanned the ANC and other liberation movements, one of the things he also announced was a moratorium on the implementation of the death penalty pending certain amendments to the legislation, which increased the number of mitigating factors that could be considered. So hundreds of people's cases had to be reviewed in terms of the new legal criteria. I spent a lot of time working on that. I did also to be involved in doing a stay of execution application. It was in the former homeland of Venda. I'll tell the story in another day, but the long and the short of it is that we had to fly and do an after-hours application. We got the order at 3 o'clock in the morning, and our clients were supposed to hang at 6, so it was a very, very close call. From there, I then was elected to Parliament in 1994, and I had the greatest imaginable privilege of being part of writing our Constitution as a member of the Constitutional Assembly. If I had done that and that only, I think I would have lived a rich and full life. But I was blessed with the opportunity to continue being in Parliament and later as Deputy Minister of Justice, Deputy Minister of COGTA, of local government, to implement that Constitution. I'm telling all of this not to talk about myself, but to make the point, one, that the decision to study law was one that was taken because I found myself in a particular context. And that context presented certain challenges. And those challenges also differ from generation to generation. You don't have to worry about being arrested or detained without trial. You don't have to worry, as I worried, about the police raiding my parents' house in the middle of the night and searching it without a warrant. You don't have to worry about having 3 of the houses that you lived in petrol bombed. But you have a different set of generational challenges. You are living in a society in which we've defeated the legal superstructure of apartheid, but the material effects of apartheid are living all around us. And Stellenbosch is one of those places where that disparity between wealth and poverty is very evident for all to see. So the question is, you as law students in 2026, what are your generational challenges? Where do you think that studying law and practicing law can make a difference to your personal and your generational mission? Secondly, that studying law does not necessarily imply that you have to practice law in the traditional sense of being an attorney or an advocate. There are many, many, many things that you can do with your legal education. My experience of practicing law was probably restricted to 4 years at Lawyers for Human Rights. But I can tell you the skills that I learned through studying law, the way of analyzing problems, of thinking through a problem, of constructing an argument, the ability to write systematically and logically and clearly. I know lawyers don't always write clearly, but I mean, still. I think those are skills that I've treasured throughout my life. So the first point I just want to make is that I think you've taken a very good decision to study law, no matter what path life will lead you on. I think you are armed with a very, very good skill set. So, okay, I think enough about me and the points I wanted to make, my points in limine, so to speak. I think it's also, and flowing from that, I think it's very, very significant that this event is taking place both as we celebrate the 30th anniversary of the adoption of the Constitution and also in Nelson Mandela Month, because I think those two events really walk hand in hand. We're celebrating 30th anniversary, the 30 years since the adoption of the Constitution, under the theme, One Constitution, One Nation, Reflect, Renew, Recommit. And I think it's a very, very loaded theme. One nation, one constitution. We are, unfortunately, at a point in our national development as a nation where those things that bring us together and those things that take us apart, unfortunately, the forces of what drive us apart seem to be gaining the upper hand. And we see increasingly how there's mobilization around ethnicity, fueled very often by mis and disinformation. And I think it's important always to reaffirm, as we did through reciting the preamble to the Constitution, that we are one nation, united in our diversity. Reflect, renew, recommit. We're not calling for an uncritical celebration of the Constitution. We need to reflect. Where are we 30 years in? And has that Constitution, can we say that the promise of that Constitution corresponds with the lived reality of millions and millions of South Africans? Are all of the choices that we made at the dawn of our democracy still relevant and still serving the purpose that we intended them to do? Many of them do, but I think there are things that we need to reflect on. There's certainly a lot of space based on that reflection for renewal. Every day that we watch the Madlingozi Commission, we see the way in which many of our core institutions have been systematically assaulted, undermined, and hollowed out. And there is a need for us to renew, both personally, but also institutionally. And recommit, to recommit ourselves to continue that journey that we set out in 1996 upon, and that journey that also informed the life and the struggle of Nelson Mandela. And I think the point is also very important that Nelson Mandela, before he became president, he was at one point in his life a lawyer. And he understood that law could be used in two ways, that it could be used to dominate or that it could be used to liberate, that it could be used to exclude or to protect. It could serve power or it could hold those in power to account. Mandela chose justice, and together with Oliver Tambo, they had a legal practice that was not there to enrich themselves, much as being some of the very, very few black attorneys at the time they could easily have done. But they represented people whose dignity was denied by apartheid, whose homes were threatened, whose movements were restricted, and whose voices had been silenced. I think another one of those pioneers that we often don't give due recognition to is Alfred Mangena, who in 1910 became the first black person to be admitted as an attorney. He had trained as a teacher, he had worked as a dock worker, and then he went to the UK and studied law, and he was called to the bar at Lincoln's Inn. But when he came back to South Africa, he was refused by the Law Society to the right to practice law, a decision which he challenged in court and won. And I think by doing that, he really played a pioneering role in both opening doors, not just for himself, but entering institutions, helping to transform them, and open the door for others to come in as well. And similarly, I mean, our country is characterized by the very, very inextricable link between race, class, and gender. And those patterns persist till today. And I think as we celebrate those like Alfred Mangena, we must also celebrate those like Sonia Schlesinger, who was the first woman to be admitted as an attorney. She had served as an articled clerk to Mahatma Gandhi in Schlesien versus the Incorporated Law Society, a 1909 case. The Transvaal Supreme Court then held that the word the court held that the word attorney meant men, and her application for admission was dismissed. 3 years later, in 1912, the Appellate Division also refused Madlingozi's application to be admitted as an attorney. The court interpreted the word persons as referring only to men, thereby excluding women from admission as attorneys. So it was only 5 years later, in 1923, in other words, just over a century ago, where a law that allowed women to be admitted as legal practitioners was admitted. The Women Legal Practitioners Act of 1923 provided that women shall be entitled to be admitted to practice and be enrolled as advocates, attorneys, notaries, public and conveyors, and so subject to the same terms and conditions that applied to men. So I think all of those legal pioneers like Mangena, Seme, Schlesien, and Wuki really entered into spaces, opened those spaces, and allowed others to come. And I think it's a lesson also for yourselves that you too will be entering spaces that you have either been excluded from or that are difficult to enter. And that our mission must not just be to enter those spaces for ourselves, but to transform them and to make it possible for others to enter. South Africa really has a very proud history of lawyers who have devoted their lives to justice. We think of Duma Nokwe, we think of Nelson Mandela, of Oliver Tambo, of Bram Fischer, Ismail Mohammed, Priscilla Jana, Dula Umar, Griffiths and Victoria Mxenge, Pius Langa, Godfrey Piche, Dikgang Moseneke, Albie Sachs, Arthur Chaskelson, Yvonne Mohoro, Zak Yacoub, and many, many, many others from different generations. They came from very, very different backgrounds. In many cases, they followed different paths, but they shared a conviction that the law must serve justice. When the law was used as an instrument of oppression, they reclaimed its moral purpose. When the courts enforced injustice, they used the courtroom as a site of struggle and resistance. And that tradition of using the courtroom as a site of struggle is far, far from over. We have now a whole new generation of public interest lawyers who've continued in that struggle. And I think University of Stellenbosch has also played a very, very important role through entities such as the Socioeconomic Rights Unit to provide a theoretical underpinning for those lawyers taking forward those struggles. I think we can also draw inspiration from many, many other international examples. I think in India, Dr. Ambedkar stands out as a phenomenal, a towering jurist and a social reformer. He became the chief architect of India's constitution, a champion of human rights, embedding principles of equality and justice into the nation's legal framework. In the United States, we think of Thurgood Marshall and the Brown versus Board of Education case. We think of the very, very important work done by someone like the late Ruth Bader Ginsburg, especially on issues of gender equality law, dismantling systemic discrimination, and I think speaking very, very inspiringly about South Africa's constitution. A well-known interview with, as she was known, the notorious RBG. She said at an international conference that, in fact, the Constitution of the United States is not where emerging democracies must look, that rather they must turn and look to South Africa's constitution. I think special tribute also should go out to Stellenbosch. And I think there we can think of those like Justice Edwin Cameron, who's a very, very celebrated alumni of Stellenbosch. He played a very, very important role before 1994 as an activist lawyer, became a justice of the Constitutional Court, where he was very instrumental in entrenching values of dignity, of freedom, equality in South Africa's legal system. And I think also a very, very courageous activist for the rights of LGBTQIA+ people, and one of the very first senior public figures to speak openly about living with HIV. And in 2019 elected as the Chancellor of Stellenbosch. I think another important and inspirational alumnus was the late Lawrence Ackerman, who also served as a Justice of the Constitutional Court. Someone whose judgments really helped establish the moral and legal authority of the new constitution, ensuring that South Africa's transition to democracy was grounded on a strong legal framework. Someone else who I think these days is maybe not remembered, well, I think more recently he has been re-remembered, is John Dugard, someone who played a very, very important role in the 70s, the 80s, just in bringing and advocating the very concept of human rights and the need to include human rights in a future constitution of South Africa. More recently, Dugard has played an instrumental role in South Africa's case against apartheid Israel before the International Court of Justice. And he's played an instrumental role in South Africa's legal team there. Now, I think I cite those examples because, again, I think they give you a sense of what others who emerged from this milieu have done with their legal training and education. And the question then, I think, that you need to ask yourselves today as you engage with the presenters who are going to come is what will you individually and you collectively as a generation do with South Africa's constitution? You will answer that question not only through what you believe, but what you choose to do with your legal education. Because the law is not merely a profession, it is a public trust. And that public trust is now passing to you. 30 years ago, we made a very profound choice as a nation to choose constitutional supremacy over arbitrary power. But constitutions do not defend themselves. Rights do not enforce themselves. The rule of law does not preserve itself. People do. And it's people of integrity, people of courage, people with knowledge. People who understand that legal knowledge is not only a source of personal opportunity, but a responsibility to society, and a responsibility that now belongs to you. We often, and I'm increasingly trying to avoid it, when speaking to those who belong to a different generation of me, I would refer to say, you are the future. No. Yes, you are the future, but you are also very much the present. So your responsibility is not something that we can talk about as if it's a deferred responsibility. It's a present responsibility. Some of you will become attorneys, some of you will become advocates, some of you will prosecute organized crime and corruption. Hey, you'll be very busy. Some will defend people who cannot afford legal representation. Some will draft legislation. Some will advise government. We wish you well, but we will welcome you very much. Some will facilitate investment and economic growth. Some will conduct research and teach a next generation, and some might also sit on the bench. But every one of you will help in your own way to shape the meaning of justice in South Africa. Today, this has been billed as a career expo, and certainly it is that. But I think it's also something much more than that. It is an invitation to consider not only the job that you want, but what purpose you will serve. We do need government legal advisors who will ensure that public power is exercised lawfully. We need legislative drafters who can translate constitutional principle into laws that respond to the changing needs of society. We need legal aid attorneys who can ensure that equality before the law is not reserved for those who can afford it. We need judges who interpret and develop the law without fear, favor, or prejudice. We need public interest lawyers who defend communities and their constitutional rights. We need corporate lawyers as well. Corporate lawyers who conduct business ethically and who help create the conditions for investment, development, and employment. We need academics who ask difficult questions and deepen our understanding of justice. So there's no one single correct career in law, but whatever path you choose, you must protect the integrity of the law. The world around us is changing at a pace faster than ever before. It's shaped by technology, globalization, and shifting social values, and the practice of law is no exception. Once, law was confined to libraries and physical courtrooms. Today it must adapt to digital platforms, cross-border realities, and new demands for inclusivity and justice. At the risk of dating myself, somewhere in some drawer at home, I still have a dictaphone. Do you even know what I'm talking about? Okay, so first of all law reports were on paper. They came out, every 2 months or so, little blue books, and then they were kept as little blue books on the shelves for a while, and then those, especially those who had money, could send them off, and they would be bound nicely into leather volumes. So you still see very often people like posing in front of the leather volumes. At the time that I started at Lawyers for Human Rights, computers were still, they'd been around for quite some time. I mean, you did quite a lot of, especially those of us who were a bit younger, did a lot of our own typing and using word processing. But the old diehards would sit with little tape recorders, and they would speak into the tape recorder, and then the little mini cassette, little tape, would go to a secretary who would sit with earphones and then listen to what the person said and sit on a typewriter and type things out. So that was a dictaphone. Basically everything was done on paper, and that has changed fundamentally. These days we have court online, and increasingly artificial intelligence is playing a bigger and bigger role. AI has tremendous power. It can search vast quantities of law. It can summarize judgments. In fact, I've spoken to many senior advocates who are saying, sadly, that they're making less and less use of junior advocates, because traditionally, junior advocates, one of their big roles was to read papers, read judgments, and summarize them. Those are things that AI can do in a matter of seconds. And it generally does it very accurately. We'll come to the not so accurate part. Can draft contracts, can identify patterns, it can even predict likely outcomes of litigation. Maybe I shouldn't say it on a public platform, but as a thought experiment a few days ago, I took the papers of a case that's enjoyed quite a bit of attention in the media. I fed the papers into ChatGPT and asked it to write a judgment. It found against the applicant. I fed the same papers into DeepSeek, and it decided in favor of the applicant. So we'll still have to wait for the Western Cape High Court to give us the real judgment. But I say that somewhat in jest, but also seriously, because those are the issues that are starting to confront us, and we can't run away from them. We've got to understand these technologies. We've got to learn how to use them, but we also have to understand what their limitations are. In particular, we can't uncritically feed things into AI, get stuff out, and then don't even bother to read and to check, and then go and stand before a court and refer to non-existent precedents or wonderfully interesting academic articles that you'll never, that appear in journals that don't even exist, like our now withdrawn AI policy. It can identify precedent, but it can't understand the moral weight of a decision. Machines can process information, but they can't possess integrity. They can produce an argument, but they can't comfort a victim. It can analyze evidence, but it can't fully appreciate the fear of a witness, the vulnerability of a child, or the dignity of an accused person. AI can't take an oath. It can't accept responsibility, and it can't understand justice in the human sense. And ultimately, that remains your responsibility. Because the future will not need lawyers who can compete with machines at processing information. They're, you know, I mean, you're playing to your serious disadvantage. We need lawyers who bring to technology what technology can't supply: judgment, empathy, ethics, courage, and human understanding. And I think, therefore, the challenge is not to resist technological change. It's to ensure that technology serves justice rather than replacing humanity. There was an interesting survey by the Thomson Reuters Institute, 2026 Law Student Pulse Survey, that recently showed that 72% of responding students identified AI literacy as an essential professional skill. However, simultaneously, 74% acknowledged that over-reliance on AI could undermine the development of their own core legal competencies. And I think that reflects a very encouraging level of insight and professional responsibility and maturity. However, the survey also showed serious institutional gaps, as nearly 1/3 of the students reported that their tertiary institution does not provide the AI skills needed for their future legal careers. And I do believe that in the years ahead, AI skills will only grow in importance, transforming how we research, analyze, and deliver legal services. Now, I do there want to, and wherever I've spoken on this, do put the challenge to universities in general and law faculties in particular, is that I do think we need to start thinking about how more and more we can integrate a responsible use of those technologies into the curriculum. Because the problem at the moment is that we've lived, unfortunately, like so many things in South Africa. Sometimes we're confronted with difficult situations and social trends, and we adopt the ostrich approach, hoping that somehow it's going to go away or it's going to solve itself. And then it develops to the point where it's you can't ignore it anymore. And by that time, very often it's become too difficult to really do anything about it. And I think this is one thing that we shouldn't follow that course. I know that many universities initially tried to ban and tried to detect, and then came to the conclusion that that's simply not going to happen. The question is, what then? How do we fill that vacuum? I mean, maybe because I straddle generations when it comes to that, I do in many areas of my work increasingly make use of those technologies. But I've never used it as a shortcut. I mean, when I want something out of AI, it's usually preceded by me sitting, often for a good 3-4 hours, thinking through the problem, making notes, finding source material, constructing a prompt, feeding it in, seeing what comes out, and then continuing an engagement. And in that way, it can become a very powerful assistant, but it can't replace, you've still got to do the work, the basic work yourself. And very often it requires of one to be taught how to do that. So I just want to conclude by expressing appreciation to the university for hosting the event, and for all of the stakeholders who have gathered here to be part of this event. I made the point to those who were going to speak earlier is that as you take more and more walks around the block of life, you very often, it's very easy to forget where you started and the influences that put you on certain paths. Sometimes those are big events in your life. Sometimes it's just a chance encounter of meeting someone and of that person telling you something you didn't know before. Sometimes it's seeing a person in distress. Sometimes it's you being in distress and someone meeting you and helping you. Sometimes it's reading something. Sometimes it's working at a public interest law firm and being handed an arbitrary case and developing an interest in that and that becoming your life's mission. So today's event, I think for me, is just an incredibly special event, and I hope that all of you, in one way or another, will gain something that will have a profound impact on the rest of your life and your career. I just want to end off by stressing one point. And that is the question of integrity. I can't stress that enough. Whatever you go on to do, whatever field of law you practice, just practice it with the utmost integrity. Because ultimately when you've traversed your professional and your personal life, and you sit and you think and you reflect back, that is probably the one thing that you are going to prize above all else, is the reputation that you have. And that is intimately tied with conducting yourself with integrity. You're going to be in a profession that is highly competitive, where the pressure is going to be on for you to perform, to bring in money into the profession. You're in a profession that also is very status conscious. People are judged by the clothes that they wear, the cars that they drive, the houses that they live in. And very often the temptation is going to be there to take the shortcut, to visit the trust fund. It'll be back on Monday. Don't do it. Don't take the shortcut. Travel the long road, the hard road. You won't regret that you did so. Thank you very much, and all of the best for the future and for now.
Thank you very much, DM, for the thought-provoking speech. I hope we are all taking notes, and apology accepted. I think you did exceptionally well. You articulated your profile, and I think it clearly conveyed why you chose the career in law over your initial career. And I think for that, we thank you also for the valuable contribution you made in transforming our society. I'm going to call upon the next speaker, Professor Tshepo Madlingozi, who is the extraordinary professor of the Faculty of Law at the University of Stellenbosch, and also the Commissioner for the South African Human Rights Commission. And as he comes, maybe, Prof, just to note that I think I would like to, I'm just doing last roll call. We have the University of the Western Cape. Okay, I'm seeing, are you 5? Okay. And we have University of Cape Town. Thank you. We also have Eddie Vos in the house. Thank you. We have Rosebank International. Oh, thank you. And we have UNISA. UNISA, thank you. And Stellenbosch, the host. Thank you very much. Over to you, Prof.
Good morning. Good morning. I hope you can hear me. I've got a bit of cold. First of all, let me greet the Deputy Minister and our colleagues from DOJ. Also to greet Professor Pienaar from the faculty, Professor Madonsela, also from the faculty. All protocols observed, as they say. I've been asked to expose you to the work of Chapter 9 institutions. But I think the DM said everything that I wanted to say in terms of the significance of a career in law. So what I would like to do is to speak at two levels. The first level being to just highlight the work that Chapter 9 institutions do, and then secondly, to expose you. This is an expo, right? Expose you to the daily working of a commissioner, just to give you a snapshot of the past 3 weeks. How much time do I have? 7 minutes. Okay, 7 points. Or as we say, 7 theses. The first thesis. So, as you know, Chapter 9 institutions are institutions supporting democracy. They are called Chapter 9 institutions because they come from Chapter 9 of the Constitution. 6 of them. The Public Protector, we have a former Public Protector here, the Public Protector, the Auditor General, number 2, the Electoral Commission, so-called IEC, you know IEC. 4, the Commission for Gender Equality. 5, the Commission for the Protection and Promotion of the Rights of Cultural, Religious, and Linguistic Communities. And then lastly, the South African Human Rights Commission. They are not an NGO. They are not part of government. We can think of them as intermediaries between government and society. They are supposed to be impartial and only subject to the Constitution. Let me say a little bit about the Human Rights Commission, just to give you an idea of Chapter 9, and I hope some of you will become former commissioners. Who would have thought that a guy like me would become a commissioner? So the Human Rights Commission is the guardian of human rights. Of course, the courts are the adjudicators, the arbiters. We are the guardians of human rights. And we've got a threefold mandate: to monitor, to promote, and to protect human rights. Monitoring basically means that as a commissioner, I can undertake, announce, and unannounced visits at any place to monitor the observance of human rights. The promotional mandate is one that I consider very important because it speaks to the question of constitutional literacy. It's fine to have a good constitution, but if people don't know how to assert their rights, it is useless. So we hold workshops, webinars, but also we give out promotional material on specific aspects of human rights. Just 6 months ago, my office issued a promotional material on intersex children for parents. What are the rights of intersex children? That is a promotional material that, in partnership with the Department of Health, we are conscientizing parents about the rights of intersex children. We also have, in partnership with the Department of Basic Education, as well as the Department of Justice and Constitutional Development, a flagship program that we call the Mood Court Program, where every year we have hundreds and hundreds of learners, grade 8, grade 9 learners who compete, quote unquote, compete, take part in a mood court competition. And we've seen how impactful it is because we're able to create the second layer of social justice champions, a moot court program. So that is also under the promotional mandate. And then lastly, most of you know us because of our protection mandate, receiving complaints and then investigating those complaints. On a yearly basis, we receive about 7,000 complaints, 7,000 complaints dealing with water access. That's our number one complaint, water access. And then 2, issues of discrimination, 7,000 complaints, individual complaints. But where we deem the matter to be systemic, then we institute an inquiry to understand what are the systemic causes of this issue. So that's what we do, that's our mandate. But at a more profound level, colleagues, our assignment is to inculcate a culture of human rights. Not just to promote, protect, monitor, that's a secondary function. At a primary and most profound level, it is to inculcate a culture of human rights after centuries of settler colonization, of genocide, of slavery, and of apartheid. How do you create a society that embraces a culture of human rights? Not very easy, not very easy. So in the last 4 minutes, let me just expose you to the exciting work of the Human Rights Commission. And I must say that if you are an empath, somebody who is compassionate, with compassion to suffer with, if you are somebody who, number 2, is interested in collective organizing, catalyzing, organizing, movement building, but also if you are somebody who is interested in holding powerful actors accountable, then Chapter 9 institutions is the way to go. Work of empathy, of compassion, of collective mobilizing or catalyzing, but also holding powerful actors accountable. So I'm just going to give you a window of the work that we do by sharing with you what we did in the past 3 weeks, just to give you an idea practically of what we do. So 3 weeks ago, we won 2 very important cases as a South African Human Rights Commission. One case against the city of Ekurhuleni for unlawful evictions and for demolition of people's homes, people's shacks. Very important work, because as you know, when people are evicted, they don't only lose houses or homes, they lose their passports, their IDs, their marriage certificates, their death certificates, they lose a lot of things. So that case was very, very important from that perspective. The second case 3 weeks ago was against a very, how do I put it in a nice way, an influential leader in KwaZulu-Natal, who you have seen in the newspapers and that case was hate speech, because he committed hate speech against members of the LGBTQI plus community. And the court found that he has to pay 250,000 hate speech against Mr. Ngizwe Nkunu. Very, very important case. So litigation is one strategy that we use as a last resort. It's always our last resort. 2 weeks ago, we then issued 2 very important reports. One report was on the Makana municipality in the Eastern Cape, service delivery. And our conclusion is that this municipality is so dysfunctional that we recommend that it must be placed under administration because it's failing to live up to the obligations. We also issued a report on the state of prisons and police stations in the Northwest, that indeed people must be arrested, but the conditions must be those that enhances dignity. So litigation, 2 inquiries that goes to unearthing systemic obligations, systemic violations. And then last week, we had 3 very important engagements with 3 important actors. One, an engagement with the Batsonga, Machangani leaders, because you'll have seen that some of their people have been killed, been mistaken to be foreigners, non-national. No one must be killed. No one must be killed. So we met with that leadership. Secondly, met with the Iranian ambassador. So as a Chapter 9 institution, we also have a global mandate to contribute to the global respect for human rights. So from that perspective, we met with the Iranian ambassador. And then on Friday, another engagement was with the South African Jewish Board of Deputies, because they also feel marginalized. So that's some of the work that we are doing. And then last week, Mandela Week, we also issued a very important report promoting a culture of human rights through the resolution of the national question. The national question that the DM was speaking to. That we can't embed a culture of human rights unless we are a nation with constitutional values. What is a nation? So that's part of the work that we do to get society to think at a higher level how to resolve the national question. Next week, we'll be issuing a policy brief. You know what's a policy brief? A brief that seeks to contribute to policy change. And this is on the issues that the DM was talking to. Disinformation, platform accountability, disinformation. As a Human Rights Commission, we take the stance that disinformation is a grave threat to democracy. We even 3 years ago established a specific unit on developing technologies, because that's where a lot of human rights violations are going to happen from the technological perspective. So we set up this unit on developing technologies, and next week we'll be issuing a profound, if I can say so, policy brief that we are calling Countering Disinformation, Ensuring Platform Accountability. How do we hold tech companies accountable? In fact, the Human Rights Commission, we were the first institution to win a case against Meta to take down something and to reveal some of the users who are committing hate speech. But also democratic resilience. How do we ensure that we can have robust discourse in society that does not descend into hate speech, into disinformation? So that is the work of Chapter 9 institutions. It's facilitative. We don't issue binding decisions. We're not a court. We facilitate discourse in society. We hold powerful actors accountable, the state, private business, but also leaders in society. But we also, at a very deeper level, profound level, engage in systemic analysis of the root causes of human rights violation. So that's the work that you do. I hope some of you are using my textbook, Introduction to Law and Legal Skills, which we co-edited with Oxford University. You must use it. Thank you.
Thank you so much, Prof, and thank you for sticking to time. I'm going to call upon the next speaker from the LPC, the Legal Practice Council, Ms. Karen Given, to the fore. Okay.
Good morning, everybody. First of all, can you hear me? Okay, great. Good morning, Deputy Minister, Professors Pienaar and Madonsela, Judge Nuku, as well as Mr. Rodney Isaacs, all protocol observed. My name is, sorry, I just need to adjust this. Thank you. Thank you so much. My name is Karen Jeevan. I'm the Director of the Western Cape Provincial Office of the Legal Practice Council. Allow me to acknowledge our valued partner in today's engagement, the Department of Justice. The LPC appreciates the need for such engagements and is honored and privileged to to be invited to participate in particularly this event this morning. As the regulator for the legal profession, the LPC looks forward to the continued collaboration and commitment to development and growth of the legal profession. So before I start with my little written speech here, can I ask of the students here, and by the way, welcome to you as well, how many of you have heard of the Legal Practice Council before this morning's engagement? That's actually quite a good turnout. How many of you know what the difference between an advocate and an attorney is? Okay, that's also quite good engagement on your behalf. I think I want to start by just touching on what the minister, the deputy minister says. It actually speaks to the core of this act. This is the Legal Practice Act, and it's our manual of operation, for the want of a better explanation. It sets out in detail what the LPC is required to do, but at the core of it, it sets out what's expected of lawyers, legal practitioners, attorneys and advocates. It speaks to the protection of the integrity of the profession, protecting the integrity of the law. All the roles that you will face one day, whether it's practicing as an advocate, practicing as an attorney, whether you're at a public interest law firm, whether you're with legal aid, whether you are a researcher, whether you are an academic. Your goal and your primary goal is going to be to protect the integrity of the law. And the LPC seeks to contribute to that, to achieve that through its mandate and its functions, which are set out in Section 5 of the Legal Practice Act. And I will touch on that lightly as I speak later. So I was asked this morning to address the mandate and functions of the LPC, the admissions and enrollment process of candidate legal practitioners, the LPC's role in developing and supporting attorneys and advocates through their professional journey, ethical standards and professional conduct expected of legal practitioners. In essence, I was asked to summarize this act in 10 minutes. It's not going to happen. But I'm going to touch on what I think is pertinent to varsity students, to university students who are shortly going to be entering the profession. Many of you started your journey with the highest of aspirations and ideals, intending to practice law for the best of reasons. It's now probably lost in a sea of subjects: law of contract, administrative law, constitutional law, where your focus is to learn and survive and come out at the end of this journey. This journey will end with your respective graduations, after which you will then enter into practice as a candidate legal practitioner. And it's at this juncture that the LPC will enter your professional career and will remain your partner for the duration of your career, in one form or another. As I mentioned earlier, the mandates and functions of the LPC are contained in the Legal Practice Act, as we call it the Act, with Section 5 setting out the objects. There are some 13 objects, and I don't have the time to go through all 13, but I think it's important that we read, and that I read to you a couple of the more important ones. The objects of the Council are to facilitate the realization of the goal of a transformed and restructured legal profession that is accountable, efficient, and independent. It is there to promote and protect the public interest, uphold and advance the rule of law, the administration of justice, and the Constitution of the Republic. Promote access to the profession in pursuit of a legal profession that broadly reflects the demographics of the Republic. So those are 4 of some 13 objects that I think are particularly pertinent to this morning's event, to Mandela Month. So the LPC, while it's trying to ensure it meets its statutory obligations, it does so to further the advancement of a transformed and restructured legal profession that is accountable, efficient, and independent, while also protecting the interests of the public. And I'll explain to you as I go on how we do that. So, as I also said earlier, your first formal engagement with the LPC will be when you commence your practical vocational training contract. And now we get to the nitty-gritty, to the more practical application of the Act and what the LPC actually does. Once you've graduated and you've secured a practical vocational training contract with a senior practitioner, you've concluded that contract, gets submitted to one of our 9 offices. There are offices in every province. That office will then assess that contract and make sure that you meet the minimum requirements to enter the profession. In South Africa, that's an LLB from a South African university. It also checks that you have met the standard to enter the profession. So it's not good enough just to have the educational qualification. You must have met your, I want to use the word moral obligation in terms of entering the profession. You must be fit and proper to enter into our profession. So that test is done right at that first stage of when you enter into a practical vocational training contract or a PVTC. We check your criminal history, your disciplinary history, and we try to get some type of character assessment on you from people who know you to make sure that you are in fact worthy to enter the profession. Without this, you will not be able to do your practical vocational training. You'll not be able to be admitted one day. So just on a personal note, I appeal to all of you, when you enter into the profession in this way, to please do so timelessly and do so correctly. Don't delay. Get your documents into us. It's our role there to assist you to make sure that you've met those requirements and that you can now start your training. And we are very, very interested in making sure that you are serving under a registered practical vocational training contract. As I said, the LPC's role is to measure your fitness to enter the profession and to check that you meet the minimum requirements. During your practical vocational training contract, you will also be required to attend further legal training offered by service providers. These service providers are approved of by the Legal Practice Council, and the coursework that they offer are also approved. So in this way, we are ensuring that we are upholding the standards that are of the profession and that you will be required to meet. You will also be required to write and pass the competency-based exams. Once again, the LPC also administers these exams. It also sets the curriculum and it sets the exam papers. It's only once you have met those requirements, you've now served under your practical vocational training contract, you've attended that additional training courses, you've passed the exams. You then bring an application for admission, which must be served on our officers after it's issued at court. We assess that application letter by letter. We check those supporting documents. We check that you've actually passed. Because again, it's in your interest and it's in the interest of the profession and the interest of the public that only those who meet the very strenuous requirements to be admitted to the practice are in fact so admitted. Should there be any tiny little error in your application, we will try to guide you and assist you and make sure, look, you haven't done this correctly, please now do it. But if you haven't met one of those requirements, we will inform the court that you haven't met those requirements, and you will need to go back to make sure that you do, or you won't be admitted. Now, you would think, who's going to do that? Unfortunately, there have been cases in the past where people have tried to sneak their way in. But we zealously guard our profession, and we need to because of the role that we play within society and within our constitutional democracy. Throughout this process, and for some of you it will be a 12-month process, for some of you it will be a 24-month process. The LPC is there to guide you and to provide some type of assistance should you need it. Our aim is to ensure that these processes are effortless as possible so that you can focus on the process or the business of acquiring the skill and the practice needed to become a successful legal practitioner. I'm not going to explain the difference between an attorney and an advocate. I think most of you do understand that, and my colleague, Advocate Gordon Turner, will also expand on that a little bit later. Sorry. So once the court now, you're now admitted at court. You are now a fully fledged legal practitioner. And the reality is some of you will not find your way to practice. You will find your way to academia. You'll find your way to business, to corporate. Or you'll find your way to a Chapter 9 institution. You'll find your way to a NGO. And some of you will find your way to practice. You'll have the option of specializing in the firm that you are practicing, or you'll decide you're going to open your own firm, or you're going to become a conveyancer or a notary. These are also courses of action that the LPC administers. It administers the courses needed and the exams needed for you should you wish to be admitted as a conveyancer and notary. Those are also formal applications to court that you will need to do, once again, after meeting all the requirements for that. Again, these are also courses of action that the LPC zealously guards. So now you're in practice, okay? And some of you will, have the courage to open your own firm as soon as you are admitted. You've hopefully got a bit of understanding of how to run a business, because at the end of the day, it is a business. The LPC offers courses, webinars, additional trainings for those who need it, because now your focus shifts. You need to make sure that your firm or your business is in compliance with the provisions of the Legal Practice Act. Again, this bundle, this book, is invaluable. I would urge all of you, if you are going that route, if you are practicing, become familiar with the requirements relating to the running of a trust account. The minister alluded to people, quickly taking money out of the trust account earlier, and he very jocularly said, don't do it, don't do it. You are going to find yourself in the deepest of trouble. Money that doesn't belong to you stays in the trust account, and you are only entitled to take that money once you've earned that fee. That's, in a nutshell, the rule for handling of your trust account. It's in a nutshell for Rule 54, which is some 54 subsections. But at the end of the day, that is what a good attorney does. He or she protects the public by maintaining and safeguarding funds that doesn't belong to you. And now I segue into the function of the LPC that utilizes most of its resources. It is the investigation of complaints. So one of the core functions of the LPC as set out in the Act is to maintain the integrity of the legal profession. So that obviously relates to the practicing side of things. And as I alluded to, it also obviously covers the protection of clients' money. But the flip side of that is that we are also independent and we are accountable to our clients. And how do we do that? Clients are entitled to submit, not entitled, they have the option of submitting complaints. And unfortunately, it is an option that clients use quite regularly. For those in practice, they may be aware of the number of complaints that come through a firm. They may be the unfortunate recipient of a complaint. We, in terms of the Act, are required to submit all complaints received against attorneys and advocates for that matter. And you are, the practicing practitioner is then required to submit a report explaining what is happening and providing a response to the complaint. And I'm happy to say that 80% of practitioners will never receive a complaint against that. So that is actually a good reflection that most of our colleagues understand the importance of their role and that they do what they need to do to maintain the integrity of the law. The other 20%, less successfully. But out of that 20%, again, and 80% will not end up in any disciplinary action because you are able to explain what you've done. Unfortunately, the LPC doesn't have to take action against practitioners who are not adhering to the code of conduct, who are not maintaining the standards expected of a legal practitioner. And in worst case scenarios, you will get a sanction, you'll get a fine, but in the absolute worst case scenarios, we then have to proceed to court to remove practitioners named from the roll of attorneys. That is the most serious misconduct and the most serious steps that we as the LPC take against practitioners. But I just want to take a step back from that very dire picture and point out that it's a very small percentage of practitioners that engage in this type of conduct. Okay? Most of us understand our role. I've said it earlier, understand and appreciate the importance of our role and know what we need to do. You know, in common parlance, do not put your hand in the cookie jar. It doesn't belong to you, it belongs to your client. The Code of Conduct, also in the Act, sets out what you are required to do in great detail. It touches on the principles of the highest standards of honesty and integrity, upholding the values of the Constitution, and also delves into issues of do not share your fees with non-practitioners. Do not advertise or tout, as we used to call it 10, 15 years ago. Now we call it approaches and publicity. It also touches on more serious offenses, harassment and sexual harassment. So the code is very, very thorough. Again, when you prepare for your competency-based exams or your board exams, have a look at the code. It's the basis of how you're going to practice, in whatever form you're going to practice one day. It is important to understand that all legal practitioners, that the stats I've quoted to you does not mean that all legal practitioners require discipline. Not to repeat myself, but the statistics show that about 80% of practitioners will not be the subject of complaints. It does, however, mean that 20% will be the subject of complaints. However, not all of these complaints will result in findings. I always find it a bit daunting to mention the discipline side at these events, because I always feel, am I discouraging people? Am I perhaps painting a scary picture to students, to varsity students in essence? What are they going to face out there? That's why I think it is important just to look at the stats and to note that it's a very small percentage of our profession that eventually find themselves. Don't be discouraged. Rather take courage and make the commitment that you're not going to be in that small percentage that's one day going to be disciplined by whatever regulatory body you are. Presumably you entered into varsity, into doing the LLB degree with the best of intentions. It was never going to be, hopefully, solely just for money, but the reality is most of us need to work for money. I'm not that naive to think that we don't need the money. But at the end of the day, this is a very honorable profession. We need to do what is necessary to maintain that status of being an honorable profession. You will hear the jokes. We all heard the lawyer jokes. But you're still here. So I think you've made the right decision. When you step out into the profession, find yourself a guiding light, someone who you admire. Watch how they operate. Watch how they run their business, how they liaise with their clients, and emulate them. And then you do the same when someone looks up to you. It's important that you look at your future, but also look at who's coming after you. One day you're going to be in the position where we are in, and you would need to then reiterate the lessons that hopefully you'll pick up from this morning. I myself am an admitted attorney. I did not follow the standard route. It was a segue. I was going to take a short break, and 20 years I'm still here, because I have a passion for the class of practitioners that I'm speaking to now, or rather the group of people that I'm speaking to now, people entering into the profession. I think we have to look after those who will come after us to make sure that our profession sustains itself and grows with the time, so to say. So I know for a fact that most of you will end up at the LPC's offices, either in Cape Town or one of the other offices. Please do not hesitate to communicate with us. As I said earlier, we are there to assist you, to make sure that your entry into the profession is smooth. And then once you are in the profession, hopefully we can offer you the guidance to continue practicing in the form that you have chosen. Thank you very much.
Thank you so much. I see we are really trying to stick to the time frame that I've provided, and I know it's not easy, but I think we are making notes, right? So we'll be able to engage with the speakers. One of the famous quotes by former President Nelson Mandela, I quote, says that no country can really develop unless its citizens are educated. And it is true. Sometimes we get discouraged to say that, why go to school and then you're not going to get a job and so on. And I think the reality is that what has been said, you know, I picked up keywords here as we are speaking from the first speaker, that's integrity, ethics, and very important now is compliance, right? There are no shortcuts. We need to comply, and your Bible is the legal practice code. So I hope you all have that. I'm going to call the next speaker from the Cape Bar Council, Advocate Fiona Gordon-Turner, to come and address us. Over to you, ma'am. Do you have a presentation?
I do.
Okay, it's up.
I don't know how I'm going to read it though, because I'm trying to do that. Oh, thank you. Is this how I page forward and back? Thank you. Good morning, or it's nearly afternoon, everybody. I'm not going to repeat the greetings. We've done those already, but I do want to say thank you to the Department of Justice, to the Deputy Minister, to the University of Stellenbosch, to the Dean, professors from the university, to have given us the opportunity to be included here. I say we because I'm not here on my own. I wanted to illustrate to you that advocates don't just stand on their own. We often work in teams. I'm what's called a senior advocate, an SC, and I have brought with me two of my junior colleagues. They're sitting to my right, and they will probably be much more able to answer the questions that are close to your hearts, because it's been a long time since I was a law student. I've been in practice. I'm in the same generation as Deputy Minister Nel. We straddle both the analog and the digital age, so I brought with me, just to illustrate, the book that always goes with me to court, which is my little hand copy of the Constitution. So I'm old school and I do look at books, but I also am trying to bring myself into the digital age with some technology. I'm pleased to see I seem to be the only one that's followed the brief and brought a PowerPoint application. So here we are, the three of us from the Cape Bar. Let me just, how's this working? It's not working. I'll try that. How do I do this? There we go. Sorry. The introductions. Who are we? We are advocates practicing in the private sector as members of the Cape Bar. I detected a note of skepticism from the Deputy Minister about those who are in private practice. He pitched us against what he called our counterparts, the legal aid ward. But let me just say, in our defense, if I may, because I'm here as an advocate, that we as members of the Cape Bar do actually do a lot of service to the community. First of all, we serve the profession by training. If you come to the bar to do pupillage, the year of pupillage that you do, albeit you don't earn any money while you're doing it, you are trained by us, members of the bar. We are the people who select you. We will give you lectures, we give you tutors, you do advocacy training. All of that is done in volunteer time. In addition to that, we also render pro bono services. Many of us have acted for public interest organizations. In addition to the pro bono hours that the LPC will be regulating, we have long had a policy of having to render pro bono services, and I see one of my colleagues from the sidebar from ENS is nodding because the attorneys do the same thing. We also have been ahead of the curve, even from the Department of Justice, in developing a prevention of sexual harassment policy. What the judiciary calls the anti-sexual harassment policy only came in fairly recently. We are also, I'm proud to say, the only bar that has a maternity policy. So we enable members, we developed this policy 20 years ago. It's about to go through a bit of an upgrade, but it's a policy that we developed because we recognized that we were having attrition from the bar because of members having to make female members having to make the choice between childcare and progressing their careers, and we have got a policy that enables them to stay. And that policy is funded from our fees. We contribute into a fund that is used to enable women to continue practicing. They can take time off, and certain of their expenses are paid for them. We also contribute from our fees into a fund that provides bursaries for students, for pupils and members in their first 2 years of practice that cannot afford to go through that very expensive period of not earning an income and then waiting to build up your practice. So there is also financial assistance available. It's quite strictly controlled. There are rigorous applications that you have to go through to get it. So we do provide, we give back as much as we try to take, and like the Minister, I also don't subscribe to the idea that because you're an advocate you must drive a flashy car. I was mocked by my colleagues many years for driving my 18-year-old Golf estate motor vehicle. I eventually succumbed to the pressure and upgraded a little bit, but you know, the aircon broke down. What can I say? That's my story, and I'm sticking to it. So what is the Cape Bar? We're a society of advocates. It's a voluntary association. We're not an employer. So if you come and join the Cape Bar, you're not getting a job. You're going to just be in a club with a whole lot of other self-employed people. You will be, as Stephen was explaining, you will be running your own business, your own practice. You do, however, have the collegiality of belonging to the society. You are supported, and you will continue to get mentoring, assistance, and also, I might say, a lot of work referred to you by colleagues. The Cape Bar is a constituent bar of the General Council of the Bar of South Africa. What is the GCB? That is it's also a voluntary and federal association. It represents the organized advocates profession. We're not the only bar. There are other bars that have formed, PABASA, National Bar Association, but we rather chauvinistically refer to ourselves as the bar because we are the oldest and the biggest. In fact, the Cape Bar is the oldest bar in the country. But there are 15 member bars. We've got member bars in every province. Okay, let's see if I can get this to work properly this time. Or can I? Maybe I've got to do that. There we go. So I've told you, I've made a slide on our brief because I'm going to go through these slides quite quickly because a lot of what I'm going to say has been subsumed by our previous very illustrious speakers. But I just wanted to let you know what we need to do. And I've called it our brief because that's what advocates get. We receive briefs from attorneys, and we exercise our own judgment and give advice, but we do need to follow the instructions. So these were the topics that we were asked to talk about, and I'll go through them one by one. So what is the role of advocates in the South African legal system? I'm going to get to the guts of you, probably going to be most interested in what advocates actually do in their day-to-day. I'll get to that in a moment, but let me just give you the high-level points. We provide expert legal representation. We must uphold the principles of justice, and we look at everything through the prism of the Constitution. That's a very important part that you take with you. I must tell you that I finished my university education before even the interim constitution had come into effect. I'm really dating myself now. So I was one of those practitioners that had to learn about our new constitutional era on the hoof, as it were. But this is something that you've got to do as an advocate and as an attorney. You have to continue to educate yourself in whatever development there is. We also contribute to the evolution of the law because we write and prepare legal documents. Our primary assistance, our primary role as advocates is to service our clients, but also to serve the court. And the very important thing that an advocate can do, and Justice Nuku may speak to this as well, is we must be there to assist the court. And when we write argument or address oral argument, we are often traversing new areas or new points or looking at old points through a different light. And in that way, we contribute to the evolution of the law. We are very much assisted by our colleagues in academia and writers and so on, but it's something that does inform what we do. We use our skills, and I'll tell you more about those skills a little bit later, our expertise and our commitment to ethical standards to ensure access to justice and the fair resolution of disputes. And that can be in any number of forums. It can be in arbitration forums, it can be in commissions of inquiry, it can be in all sorts of things. And represent a diverse number of people. Our clients can be individuals, they can be businesses, government entities, various organizations, and we can handle a wide variety of cases. Your training as an advocate will cross a whole cross-section of things. When I was a student, the now retired Judge Dennis Davis, I remember him telling us in final year, you are now at the point where you know more law than you will ever know in your whole life. That's where probably those of you who are students are now. You now know the most, because what happens after a point is you start to hyper-focus in certain areas, and those other bits that you learned start to seep out of your brain. So be grateful that you now know as much as you do, and anchor that and take it with you. So when we start out, we have to be able to cover criminal aspects, civil aspects, administrative proceedings, and constitutional matters, all of those things. I'm not going to dwell on this point because I think Ms. Jeevan has already referred to the Legal Practice Act in some detail, and you will see my very last slide is the acknowledgements. You must always, as a practitioner, acknowledge your sources, like you've learned in academia as well. But broadly speaking, there are two types of advocates. There are referral advocates and there are Fidelity Fund advocates. The three of us are here today. We're all referral advocates. You cannot be a member of any one of the GCB constituent bars unless you practice as a referral advocate. So we don't consult and engage directly with members of the public. We only do that via an instruction from an attorney. We practice exclusively on instructions from attorneys in private practice, or there may be community-based law centers or university clinics. There's a very good clinic here, or there was a very good clinic here at Stellenbosch University from whom I received instructions once, run very, very well, and does some outstanding work. So these are the main things that we do as advocates. We are the guys that put on the black suits, the black robes, okay? I was going to tell you, and I think I'm reading the room and I think this can go down. One of my colleagues describes the difference between advocates and attorneys as saying, advocates, we're the guys that walk on water and jump over tall buildings. It's that we get to do the stuff that looks a little bit sexier than what attorneys do, because we are most often in court. We're the ones that are standing up presenting our clients' cases. We have to be good at the art of persuasion. That is what an advocate does. You are there to persuade a judicial officer to the point of view of your client. So what do we do in order to get there? We draft court documents. These are things called pleadings, which are in a trial proceedings, that's what they are, or in motion proceedings, we'll be drafting affidavits and notices of motion. We have to know how to present and lead evidence, and that might look easy, but it's actually quite an accomplished skill. You've got to know the difference between a leading question and a non-leading question. We have to know how to examine and cross-examine witnesses. There are some rules in cross-examination. For example, you never ask a witness a question to which you don't already know the answer. You don't open it up to them. You've got to prepare very well for cross-examination, and these are skills that we teach you when you come for our training. We have to know how to draft written argument. Drafting argument is similar to, but not the same as drafting the essays and so on that you've been used to at university. You must reference your sources, of course. You must have a structure, but there is a skill to that as well, and it's similar to writing a judgment. You also have to know how to present oral argument. And oral argument is also a skill you need to know how to get to the point quickly, which I'm going to have to do a little bit more of now. So legal advice and opinion. We also ask to provide legal advice and opinions to attorneys and clients regarding the merits of a case, strategies, and the interpretation of statutes and laws. Very important thing, I'm not going to dwell on this because it has been said before, is a very important part of the advocate's role is to uphold ethical standards. We are bound by a strict code of professional ethics and conduct. I'll do that in a little bit more detail just now. We must adhere to principles of honesty, fairness, and respect for the law. You've heard several speakers now talking about integrity. I could not agree more. It is the most important quality for any legal practitioner, particularly advocates, to have is integrity. Your integrity is your most important asset. It is more valuable than your house, your car, your jewelry, your fancy suit, your smart shoes. It is the currency that allows judges to trust you. Justice Nuku may speak to this as well. Judges rely heavily on what legal representatives tell them because they are busy. They don't have the time to check everything. You are relied upon as somebody who's going to present a case fairly, honestly, and in accordance with the law. And your integrity, you forgive me, I hope this doesn't offend you, your integrity is like your virginity. Once you've lost it, you don't get it back again. So once a judge knows that you are not to be a judicial officer, knows you are not to be trusted, you will never be trusted. They will second guess everything that you look at, that you submit. Right, same but different. This is the heart of what I was really asked to come speak to, about what's the difference between attorneys and advocates. We're both regulated under the same legislation. You've heard about that from Ms. Jeevan today. Both attorneys and advocates are legal practitioners. We both have to meet minimum qualifications, undergo practical vocational training, and sign, during that period, your practical vocational training contract, and we have to pass a competency-based examination or assessment. But I like to explain the difference between us as if you had a medical problem, the first person you go and see is your GP. So the attorneys, without any deprecation, are like the GP. That's the first place you're going to go for advice. When you've got a serious problem, you need surgery, you need to go to the guy with the scalpel. That's us. We are the specialists who go to court. You really don't want to. It's a bit of a Confucian curse, actually, to have to need an advocate, because then you know you're in serious trouble. Then you're litigating. So we are the specialist litigators. But our professions are symbiotic. Attorneys also do court work. Counsel also do opinion work and give legal advice and instructions. But we work together, we mesh together well, we depend on each other. We are frenemies. Okay, these are the major distinctions. There may be others that Gabi and Zanri point out or that you raise in your questions. Okay, an advocate does their practical vocational training during pupillage. An attorney does it as a candidate attorney. An advocate is independent of all clients. Our independence is our most important feature. That's not to say that attorneys don't exercise a measure of independence. Of course they must. But attorneys also build relationships with clients. Our clients as advocates don't belong to us. It's brief per brief. So we are briefed by, as advocates, we are briefed by an attorney acting for a client, whereas an attorney takes instructions directly from a client, can do things like accept service of documents, stands in as the client's representative. We are, as advocates, are part of what's called a referral profession. We primarily appear in courts and other forums, such as arbitrations, tribunals, commissions, boards, and so on. Attorneys also appear in courts. They are automatically entitled to appear in lower courts, and they may, if certified under, I see I've got a typo here, section 25.3a, and that's when I was watching Spain and Argentina, sorry. I got distracted in overtime. That should read the LPA. There's a section permits you under attorneys also to gain to be certified to appear in the high courts. Our expertise as advocates is in trial, motion, court, and opinion, and appellate appearances and opinion advocacy. Attorneys can do some of that as well, and many do, but they also give general advice on the law. A very important distinction is that advocates, we practice for our own account only. We're all little businesses. Andries a business, Gabi's a business, I'm a business. We share our expenses, but we don't share our profits. We can become members of the bar. Attorneys can't become members of the bar, sorry, but they can practice in partnership or in firms or in companies. They're usually what's called an Inc. Okay, so now you want to know, how do you get there? Have I skipped over one? No. The process of becoming an advocate. So this has also been looked at before. To become a member of a constituent bar of the GCB, you need an LLB. You need to successfully complete a year of pupillage. You need to be admitted as an advocate by the High Court, and you need to be enrolled with the LPC in terms of Section 30 of the LPA. All members of the GCB and its constituent bars must practice exclusively as referral advocates, and you have to occupy chambers. Let me just quickly give a little bit of an explanation. So this is how we know where you are. And this is kind of how we keep an eye on you, because one of the things that we're responsible for is making sure that none of our members go rogue. We've also got the LPC in the background, but up until the LPC came into effect, the bar was responsible for disciplining not only its own members, but also other, we receive disciplinary complaints. All of these things, by the way, we process free of charge. Disciplinary complaints from members of the public about advocates who are not members of our bar, and we deal with those issues as well. So one of the ways that we keep an eye on what's happening is we all occupy chambers in the Cape. we're in a precinct in Queen Victoria Street behind the courts, occupying about 7 different buildings. An advantage of being a member of the bar is that, unlike attorneys, if you were to set up practice as an attorney, you would have to lease premises. A landlord would maybe expect you to sign up a lease for a year, maybe, and then you're locked into that, and you've got to fund that. But if you come and practice at the bar, we at the bar will find you chambers, we will allocate chambers to you, that you pay for, but we'll allocate chambers to you in one of the approved buildings. There are about 7 or 8 of them in Kioram Street. And you can be there for a month and then decide, that's it, you can't do it anymore, and you can leave. And the bar stands in for that. We've got different arrangements with different landlords, but it gives you some flexibility that you're not locked in. There are very few other jobs or businesses that you can go into where you've got that advantage. As I've said before, we're bound by our uniform rule of ethics. That's our bar's code, the LPA code of conduct, and we've also got, at the Cape Bar, we've also got our local rules. Okay, pupillage. I'm going to let Gabi and Zanri handle whatever tricky questions you have on that, because I'm not as up to speed on it as I had, having done it back when there was the Rinderpest. So you do a practical course in legal drafting. You do advocacy training. The people who undergo specialized training, and this training, by the way, has been informed by training done in other countries. We've had barristers from Ireland and the UK and Singapore and so on also train, and we now also train with them. Some of our members go to the international advocacy training courses. These are also supplemented by lectures, which follow a prescribed syllabus. And what you also have allocated to you, or you can choose one, you have a mentor who is a practicing advocate, usually of 5, I think it's a minimum of 5 years, 5 years experience, and you will be with that person in chambers. You should theoretically be joined to them at the hip. They go to court, you go to court, you go see a judge in chambers, you go with them to see a judge in chambers. If they're sitting consulting with a client and an attorney, you're sitting with them, they help you learn how to draft. You will have to absent yourself from time to time to go to your lectures and your advocacy training exercises and so on. You're also expected to, so that mentor is supposed to guide you. Through that person you learn what it's like to be an advocate. You see how they present things in court and what they do. You're given weekly assignments to do. It's quite onerous. There's a lot to do. It's a heavy program. And you'll write a mock exam before your actual bar exam. It's a full-time, demanding program. It runs from January to December each year. Don't get time off. When you successfully complete the practical course, you have to write, for our bar, you have to write the National Bar Examination Board exam, also known as the bar exam. We are the only bar that requires you to write an examination. The other bars don't have an examination. It's the thing that distinguishes us, and we've been put under pressure to let go of it, but we feel it's an important standard bearer. People come to our bar to write that and then sometimes leave and go off and practice in some other form, because the training and the rigor that you have to go through to pass that exam is important. And it's also, if I may say so, it's doing a little bit of marketing for the Cape Bar, we're a brand. If you belong to our bar, you're a brand. People know that you've gone through at least those hoops to get to become a practicing advocate. And then there are some of our pupil members who also, in addition to writing the bar exam, have to write the legal practice examination as well. Those will be those who haven't practiced as an attorney before, because if you've been an attorney, you will have written the LPC examinations in that context. Okay. The exam, telling you briefly about it, it comprises an 8-hour legal drafting exam. Then you have shorter. Yeah, you feel like you've run the comrades after you've written that exam. Trust me, I've ached in every part of my body. Then you write shorter papers. I haven't quite got them in the right order. You cover magistrates' court and high court practice. You write papers in motion court proceedings, civil trials. Evidence is embedded in those. You write a separate paper on criminal procedure, and you write on ethics. Very, very important. Then we also hold oral examinations, not for those who've passed and they're written papers, you don't have to do it, but if you've slipped up in one or others, we give you orals, and there are orals held all around the country, and there is a judge of the High Court that presides over those to moderate the examinations as well. And we're very grateful at the bar and the NPEB for those members of the judiciary who make themselves available to do that. All right, so what do you need to succeed as an advocate? You need to be an independent thinker. You need to be able to, you can't just follow the crowd. You must be a confident and fluent speaker or skilled orator. You mustn't be afraid of speaking and writing. You must have a keen dedication to justice. You must enjoy analyzing and solving problems. You can get a variety of things that get thrown at you. And sometimes things can be very challenging even if the amount of money is very small. The legal issues can be very complicated. You mustn't be easily intimidated, and that's because you're in an adversarial system. The late Justice Conradi, who passed away recently, once said to me that at a point where I was at quite a stressful point in my career, he said to me, "Oh, so you've made it." So I said, "What do you mean?" So he said, "Well, you're still here." So I said, "Well, what do you mean I'm still here?" He says, "Well, you know, you're raising a child and you're developing a practice and you're still going." And I said, "Well, what do you expect?" I said, "Lots of people do that. You know, they have families and they have jobs and they have careers, sorry." And he said, "No, but this is the single most stressful profession that you could be in." I said, no, that can't be right there. There are other jobs that are stressful. Being a fireman is stressful. Being a neurosurgeon, when a micron away from a neuron can paralyze somebody, is stressful. He said, "No, this is the only profession where there's somebody waiting to knock you down at every point. It's your instructing attorney is going to be critical of you. Your client's going to be critical of you. Your opponent's going to be critical of you. Sometimes you have more than one opponent. The judge may be critical of you. So everything you do and everything you present, everything you work on is under a microscope. So you've got to be tough. You've got to grow a thick skin. So you mustn't be easily intimidated by criticism. And when you stand up in court, you must obviously be courteous to and respectful of the court. That's our duty as officers of the court. But we must also be unflinching in advancing every point that is permissible in law on behalf of our client. That's what we are duty-bound to do. You must be self-motivated and disciplined. You must have stamina. This is not a 9-to-5 job. It's not a 9-to-5 job. It's very unpredictable. Sometimes you're very quiet. Sometimes you can have a whole lot of work that comes unexpectedly from different sources, and you can't say no. Many times I am sending emails to attorneys at 2 or 3 in the morning because that's when I finish the work. And that's what goes with the territory. And you must be determined. Okay, so what are the skills and competence? Those are the personal attributes. What are the skills you need? You must have a sound foundation in the law. You're very fortunate, if I've heard about the various tertiary institutions that are represented here. You're very fortunate if you're attending any of those. A strong academic performance at a university is an enormous advantage for a career at the bar. We do look, when we are selecting pupils, we look at your academic performance. We've got a weighting system of how much we allocate on various attributes, but there's a heavy weighting on your grades because there's a correlation between those who know the law and those who are going to succeed as advocates. It's common sense. You must also be willing to be a student for the rest of your career. You are always going to be learning. I never stop opening books. I've been practicing as an advocate since 1993. I still go back to basics. I go and check the text. I check everything. I make my juniors crazy because I ask them if they've checked. You read until your eyes bleed. It's kind of like being a judge because they read a lot too. You must be able to listen attentively. You're going to consult with people. You must hear what they say. I heard somebody talking about just Deputy Minister. You must have empathy. You must connect with people. You must be able to hear their stories, but maintain the barrier of independence so that you don't become them, but listen to them. And you must be able to read and assimilate factual and legal material quickly. You sometimes have files and files and files and files to read. Sometimes they come to you digitally. That's where a lot of our briefs come to us. Sometimes they're in great big lever arch files. Okay, you must be able to do research. You analyze and think critically about statutes, case law, legal precedents. You must have problem-solving skills to be able to apply analytical thinking to resolve issues. Sometimes what seems like an obvious solution isn't the obvious solution. Sometimes there's something that's simpler that you may not have thought of. I was looking at, for example, at a contract the other day, and I was over-interpreting the various clauses, and somebody said to me, but what about that thing in the Consumer Protection Act? You've got to connect dots and integrate different areas of your knowledge. Very important thing is command of language. You must be able to succinctly, and I cannot emphasize this enough, succinctly convey facts and applicable legal principles. If you are an advocate, you are presenting things to a judge. Judges are heavily burdened. It's relentless. Files come at them all the time. They have huge volumes of stuff to read. Less is more. Get to the point quickly. Give the judge the inverted pyramid approach. So you start out with this much information that you read and assimilate. You start analyzing it and you work out what the issues are. The pyramid gets narrower and narrower and narrower until you get to the point of the pyramid, at the bottom of the pyramid. It's apex of the pyramid, I suppose. But if we're inverting it, that's what the judge wants to hear. He can't hear about everything that's gone into it. Tip of the iceberg, I suppose, is the better metaphor. You must be able to write well and express facts and points of argument on behalf of your clients. You must be able to see both the forest and the trees. So much as I've said you must get to the point, you must be conversant with the detail. You must know those things. Sometimes the devil is in the detail. Sometimes it's the detail that wins the case. And it's something that I tell all pupils and juniors that I work with is never, ever, ever underestimate your opponent. You could have a very inexperienced opponent who finds just one point that can scuttle your case, which is why you must pay attention to every detail and you must know every detail in fact and law. You must have uncompromising independence. This one I also cannot emphasize enough. You must have a sound work ethic. Successful advocates are conscientious and diligent. There's an advocate at the Johannesburg bar called Altus Jubei. I saw him at a function last year. He's in his 80s. Altus is in his chambers before 6 o'clock every morning, every single day. Those are the hours that he keeps. You may have been following, if you look at social media or follow on YouTube, the proceedings that ran in the Cape High Court last Tuesday and Thursday in front of a full bench concerning the president trying to stop the Section 89 inquiry. And he was represented by a very esteemed colleague from the Joburg Bar, Wim Trengrove SC. Wim is a person that's known to rise at 3 or 4 in the morning to work. He works hard. He's very talented. He's very brilliant. But this is why I put it in red here. I tell this to all the pupils when I get a chance to lecture them. Hard work beats talent, unless talent works hard. There are also some soft skills that you're going to need to help you to succeed. You need to be able to work cooperatively and communicate courteously with others. You're going to work in teams with instructing attorneys and candidate attorneys, expert witnesses. That's actually one of the parts of the job that I really enjoy. Over the range of cases that I've done, I've worked with accountants, actuaries, medical doctors, statisticians, psychologists, psychiatrists, engineers, shipbuilders, and you need to understand what they do in order to be able to present their evidence if you're calling them as your witness, and also if you want to cross-examine the counterpart expert, you work with that expert closely so they teach you enough of the rudiments of the case so that you can cross-examine successfully. You will also work with lead counsel if you're a junior, co-counsel or junior counsel. That's why I brought my junior colleagues with me to illustrate that. You have to be able to get along with opposing counsel and attorneys. And of course, most importantly, you must be able to communicate effectively with judges and presiding officers and court staff. Very important to be courteous to all people. There are a lot of people that make the machinery of justice work, and they all deserve to be recognized, have their dignity recognized. Greet them, look them in the eye, try and remember their names, be courteous to them. Don't be cross with them when they can't get you the piece of paper or the file that you want. You must be able to work in an adversarial environment. Somebody mentioned, one of the speakers mentioned that I think it was Deputy Minister. We work in a very competitive world. It is very competitive and it gets very tense and sometimes very unpleasant. And you, by nature, when you are litigating, whether you're criminal litigation or civil litigation, it's adversarial, and you've got to be able to cope with that and put your own ego and your own feelings aside. You must be able to manage time well and work under pressure. Okay, then the next topic that I was asked to talk about is career opportunities in areas of specialization. You've heard about some of these already. Beyond the bar, there are opportunities to work as an advocate in Chapter 9 institutions. At the NPA, you'll be hearing from them. The Office of the Family Advocate, I'm not sure if they're speaking, but I know they're represented here today. You could work in the executive as a legal advisor in various departments in the private sector, as in-house counsel to corporate entities. And what about at the bar then? What opportunities are there? Well, the advocates at the bar have developed specialized practices in any number of things. Sometimes they do it consciously, sometimes it develops just organically for you. I haven't put on here public interest law, but that is actually something that quite a few of our members do. Deputy Minister Nel probably knows very well our very esteemed senior colleague Jeff Budlander SC, who was the founding member or a founding member of the Legal Resources Council, and he does an enormous amount of public interest work and pro bono work. In fact, so much so that he's been recognized internationally for his contributions to pro bono work. So those are various things you can do. Then what are the things that you could possibly also do while you're still an advocate? You can be continuing in private practice, but you can receive briefs to be leaders in commissions of inquiry. You would have seen that with the Zondo Commission, the Madlingozi Commission. Members of our bar or our sister and brother bars are evidence leaders. Many of us also act, I don't because I don't really like it, but many of us act as mediators, where you settled alternative dispute resolution, where some of you may be doing courses in that as part of your studies. Very, very important part of the administration of justice, taking the load off the courts, going into alternative disputes, and many people do that, or acting as arbitrators. So you can be an advocate, and you can be as brief as an advocate one day for one of the parties, but you can also be sitting as an arbitrator. It's kind of like being a private judge. Some advocates at the bar are appointed as acting judges. I've been very privileged to have that opportunity a couple of times. Let me tell you, you learn a lot as an acting judge. You see things from the other side, and you learn to appreciate how very, very hard judicial officers have to work. And some advocates at the bar may in time receive permanent appointment to the bench. I'm very proud to say that 4 of our members have recently been elevated, 3 to the Western Cape High Court, 3, and they're all women, Justice Nkomisa Moyosi, Justice Diane Davis, and Justice Susan van Sale were, until a couple of months ago, my colleagues at the bar, and they're now they're now Justice Nuku's colleagues on the bench, and Justice Savage has been elevated to the Constitutional Court, so we're very proud to have that. Our bar is one that is difficult demographics because it largely reflects the demographics of the Western Cape. But we are trying to transform our profession and our bar to make it more representative of certainly at least of the Western Cape. And part of that job of transformation is also in making it more gender representative as well as our demographic racial composition. So now this is not part of my brief, but I'm just going to give you some unsolicited advice. If you want to become a member of the Cape Bar or another bar under the GC umbrella and you want to apply for pupillage, first of all, you can't do it while you're still a student. You have to already have your LLB. So it is preferable to have acquired prior legal experience as a prosecutor, a candidate attorney, or an attorney, or in any of the other organizations that you've heard mention of today. A Chapter 9 institution, legal aid, any of those people that would, the state, any of those organizations that are willing to offer you that opportunity. All of that experience you bring with you. There's also an underestimated element is life experience. It's a good thing to actually take a break, do something else. There's no shame in doing that. We have members of our bar who have been journalists before they came to the bar, or teachers, doctors even. Many people have had other jobs, academics too. Many of them have had other jobs in other fields entirely, maybe do their studies as a mature student, and then later on come to the bar. And that life experience is invaluable because it gives you many of those soft skills that I spoke about, ability to work in teams, ability to communicate with people, confidence, and so on. It's advisable if you're going to do pupillage at one of our bars to have reserves to sustain you through the year of pupillage when you earn nothing, and you may not take any other form of employment during pupillage, and because of the time it will take you to establish a sustainable practice. You must make your application for pupillage in good time, and please do, if you join us, enjoy the independence and collegiality that a career at the bar offers you. And I've got my acknowledgements here if any of you want to take down these websites where you can get more information and links to what you need to know. Right, thank you very much.
Thank you so much, Advocate Fiona. We're going to open one round of questions quickly to the previous 4 speakers. The roving mics are here. We're just going to, by show of hand, you introduce yourself. And one question, please. I know sometimes you'll be asking 4 questions. There will be someone who will be asking a similar question. If you note that that question was asked, please don't repeat the question, right? So, 5 hands. There's one here. There's another one over there. And there's one here. 1, 2, 3, 4. The last one. Okay, we have 4. We're not going to open it up after this. Your name, the institution you're coming from, and your question. 1 question. And if it's already asked, please don't repeat it. It will be responded to accordingly. You may proceed, sir.
Hello, everybody. My name is Madlingozi from
Please stand.
Sorry. Hello, everybody. My name is Madlingozi from Stellenbosch University. I'm a first-year LLB student, and my question is directed to Professor Madlingozi, and it's revolving around Chapter 9 institutions. I would like to ask, are Chapter 9 institutions powerful enough to address structural problems in South Africa, or do they just deal with individual complaints after the harm has been caused already? That is my question.
Hand, you, ma'am.
Good afternoon. I am Vanessa Ngumalo, a final year law student from the University of the Western Cape. My question is directed to Advocate Fiona, and it's with regards to how you said we shouldn't be intimidated by criticism. So when you consider your experience, your knowledge, and maybe your observations, what are the ways in which one can build a healthy relationship with criticism, and what are the consequences of having a bad relationship with criticism? Thank you.
Did you get that? The last part of your question, ma'am, if you can repeat it, speak to your mic, ne?
Oh, the last part of the question is, what are the consequences of having a bad relationship with criticism?
Yes, yourself.
Good afternoon, everyone. I'm Musam Shomi, and I'm from UNICE. I wanted to ask from Prof Madlingozi. So I just wanted to find out the possible career routes for a fresh LLB graduate at the Human Commission. And also, since it's not a traditional or the formal way to go about as a law student, it's not the traditional way as well, I just wanted to find out do you have any initiatives in place to make sure that you expose us as law students? Also, do you have any vacation works initiatives or even internships to make sure that law students are exposed to the Human Rights Commission? Thank you.
Thank you. The last question, it was from yourself, yes.
Hello everyone, my name is Pamelo Trishane and I'm a first year at Stellenbosch University LLB. My question is directed at the Deputy Minister himself. It's regarding the Constitution in the preamble. As it says specifically the line that South Africa belongs to all. To my knowledge, that line is inspired from the Freedom Charter, and my question is, what was the need to directly take that line from the Freedom Charter? Because I've heard certain individuals say, why not simply South Africa belongs to South Africans? Was there a need to say South Africa belongs to all? Because that has legal implications. Thank you.
Thank you. They are closed, ma'am. Can I start with you, DM? And then we'll take the others. Can I have the mics back?
No, thank you very, very much. I think it's a very good and a very topical question. I'm going to answer it from a variety of perspectives. And maybe let me start by just giving, let me start answering legally, and I'll move then to legal political answer. I think if one looks at the Constitution in totality, there is a very clear distinction between the rights and the duties and obligations that rest upon citizens and those that pertain to all who happen to be in South Africa at a given time. And I mean, there are clearly rights such as the right to stand for public office, to vote. There are also certain socio-economic rights which belong to citizens. There are also rights that apply to anyone who's in South Africa. And that stems from the very fundamental, if you go to the founding provisions of the Constitution, and one of the central values in the Constitution and the constitutional jurisprudence is that of human dignity. And a belief that anyone who is in South Africa is a human being and deserves to be treated with dignity. There are also rights within the Bill of Rights that speak specifically to different categories of people. And one of the rights that is almost elevated is that of the rights of children. And we're saying that the rights of children need to be paramount. And so therefore, when it comes to issues of health, of education, the courts and the Constitution tend to elevate those rights and to make them of a more general application. Now, there's also, seeing that this is a current, and I'm now transitioning to the legal politico side, is that the issues of immigration, migration are very much part of our national discourse at the moment. And I think we need to deal with those issues head on, confront them, and have an open and frank national dialogue about them. Many of those rights, we must also forget, we do it because it's the right thing. But how does the American expression go? You do well by doing good, or while you're doing good. And I want to focus there on the issue of health. I think South Africans are genuinely concerned that our public health system is already overburdened and that there are many non-citizens who are also making use of that health system. And clearly, that's something that deserves attention. But we must also be careful not to, as the English say, cut our noses to spite our faces. Because the reality is that viruses, that communicable diseases, aren't going to check what passport you carry. And if we don't treat people, then we ultimately are going to become the very victims of certain of the diseases. Coming specifically to your question, and maybe just before getting there, is to say that I think the President, in addressing the nation on the 7th of June on issues of immigration, I think really encapsulated the issues in their totality. To say that South Africa is a sovereign nation, as it says in the preamble, and we have the right to determine the integrity of our borders. We need for national sovereignty to know who is in our country, at what time, for what purpose, and under what conditions. That is not a reflection of being negative towards anyone. It's a central part of national sovereignty. At the same time, the constitutional responsibility to enforce those laws belongs to the state and to no one else. We encourage citizens to work with the state, to assist the state, to provide the state with information, but ultimately it's up to the state to enforce those laws in terms of the Constitution and the law. And we've made it very clear that as the state, we will not allow anyone to take the law into their own hands. Because once we go down that route, there's no turning back and there's no end. I'm going to come now to your question via a little cautionary detour. Why it's also important not to allow people to take the law into their own hands is that once you have defined others as alien and act upon that without impunity, it's a short step to follow that logic even to your fellow citizens who are different from you. And the stories of South African citizens who, because their language sounds maybe a little different to others, their skin tone is a bit different, also then to start victimizing them. I always take note when we are reciting the preamble to the Constitution, especially the last part. It's usually quite plain sailing until we get to Mudzimu Fatuchedza, Africa. Then many tongues start getting wrapped up. And so I think we really need, as a country, to be very, very careful. We are a very diverse nation. We proclaim that we are united in our diversity. But if we don't maintain a constant vigilance, it's very, very easy for those with a variety, often a very selfish and narrow interests, to mobilize us against each other. And that was the essence of what constituted apartheid. It was divide and rule. And that's why when I spoke about the UDF, we said the slogan of the UDF is apartheid divides, UDF unites. We must always work to uniting. And that phrase in the preamble, yes, it does come from the Freedom Charter. Why was that wording chosen? It was chosen at a time when the very essence of apartheid, let me just also take a step back there. During the course of the struggle, that tradition that I belong to, we defined apartheid as colonialism of a special type. Because we said that within the boundaries of one and the same country, you have a colonizing nation and a colonized nation. The essence of apartheid was the negation of the citizenhood of black South Africans, and Africans in particular. And that constituted really, if anything else, the core of the struggle for liberation, is the affirmation of citizenship, that South Africa belongs to us. And that is why it was formulated, is to say that South Africa belongs to all who live in it. I think we can all understand the ambiguity of those words in the current context. But I think we need to interpret them in their proper historical context. It's an affirmation that South Africa belongs to all united in our diversity. The issues of citizenship, I think, are dealt with properly in the Constitution. As I also said, is that as we celebrate 30 years of the adoption of the Constitution, part of that celebration is also to reflect and to say maybe are there areas that we can tighten up definitions, etc., based on the current experience. Let us reflect on those matters, but also let us reflect upon them carefully. We took the decisions that we did also based on a very painful and divided history. We took those decisions based on lessons that we learned from across the entire globe. I maintain that South Africa is not a xenophobic nation. It does not reflect who over history we've been. Through successive generations, people from all over the world, all over our continent, have come to South Africa, have lived in peace and harmony, and have become South Africans over time. What we need to ensure is that those basic immigration laws are enforced, and enforced consistent with the Constitution, so that we don't end up conflating a non-enforcement of laws with other things. I hope that helps in some small way to answer. Thank you.
Can we just test these mics? If you switch it on there, I'm sure a green light will come.
Testing.
Yes, you can proceed.
All right. The question that I was asked was about criticism, how one deals with criticism, relationship with criticism, and the consequences of a bad relationship with criticism. So I'm not 100% sure whether the question was meant to be criticism personally, criticism of one's work. So I'm going to address both of those. You will, and I'm speaking now wearing my hat as an advocate and here representing the Cape Bar and our profession as privately employed advocates, you will encounter criticism in a personal capacity. I spoke to that briefly when I mentioned the adversarial and very competitive environment in which we work. You will attract criticism. Sometimes it can be very unpleasant. You've just really got to grow thick skin. Trust me, it's taken me a very, very long time to learn that lesson. And I still have to steel myself on days. And one way to deal with it is just to have downtime, to have other interests, to have friendships outside of your profession. Very important to have a work-life balance. Insofar as you can do that with the unpredictable working hours that we do. Sometimes your criticism will come from your professional body because of something that you've done. Somebody may lay a complaint against you. Ms. Jeevan spoke a little bit about disciplinary inquiries that the LPC runs. Our bar also has disciplinary inquiries when there are complaints made about our members. Then one has to deal with them. Honestly, you have a right to a hearing. You will be able to put your point of view forward, and your peers will judge you on it. And if it's not the bar's disciplinary proceeding, but the LPC's proceeding, you can also go through that process. So due process will be followed, and you just have to steel yourself and trust to the process. If you have acted properly, then you will be vindicated. As far as professional criticism is concerned, of course you're going to get that every day. That goes with the territory. Somebody is looking to break down your argument or out your point. So how do you deal with that? You must deal with it by being better. Do your job better, work harder, do more research. Sometimes your opponent will cite a case and say it's authority for proposition X, and you think, okay, you go and read the case and it doesn't actually say that. You need to be quite scholarly as an advocate and go and dig down a little bit deeper. You will have heard, I'm sure, we will have been taught about finding the right of a case, finding points of distinction from other cases when authorities apply and when they don't apply. And that's something as counsel that you'll have to do quite assiduously, because often your opponent will innocently, not necessarily maliciously or deceitfully, tell a judge with great confidence, well, this proposition that I've made to you, the submission I make to you, is supported by the XYZ case, and when you go and look at the XYZ case, it says nothing of the sort. The same thing, I'm sorry to say, often applies not to academic publications that come from Stellenbosch University, of course, but from certain published authors. I must warn you, for example, Lawsa, which is a very good resource, and there's some very good contributors to it, but sometimes it's a bit patchy the way they edit it. So there'll be a proposition, there'll be a single sentence and then a footnote, and you go and check the footnote, and the footnote takes you to a case that says something different. So it's been the editor who's looked at that has summarized it incorrectly. So you must always exercise a judgment, and that is where I agree heartily with the Deputy Minister that that's something that AI will not be able to replace, is the judgment that you exercise. So when you receive criticism of your work, that is because somebody is judging it in a particular way. Stand back from it. They may be right. They may actually have a point, and sometimes you have to concede. And if it's a judge asking you, sometimes if you can't think on your feet and come up with an answer, you may have to concede that point. Most judges, if you tell them you've been caught unawares and you ask for an opportunity to reflect or to make later submissions, will give you that opportunity. That's part of the fairness of the system. I don't know if that answers your question or whether I've hit the mark at all. Yes, I'm seeing nods. Okay, thank you.
Oh, there was no question for LPC. Prof Madlingozi?
Thank you so much for those two questions. As one of the first contributors to Closer, I'm feeling criticized and feeling sensitive. There were two questions to me. The first one was about opportunities at the Human Rights Commission. Yes, indeed, we do advertise for internships. That's number one. But number two, you asked how do we expose students to opportunities. As I said, we do a lot of promotional work, about 2,000 promotional outreaches a year. We have what we call human rights champions. These are ordinary members of the public that we train to be our eyes and ears in communities, human rights champions. We then have 18 children rights ambassadors. These are children who are in high school, who we train to be our ambassadors, 18 per province. Yes, there are opportunities for job shadowing to be our shadow. We don't have vacation work, but there is opportunity to job shadow. And in terms of career opportunities, one, we have researchers. So one can be an ordinary human rights researcher. Two, we've got human rights monitors. Human rights monitors, people who monitor human rights and work in our offices. Thirdly, we have advocacy officers. Advocacy officers who help us to do this outreach work that we are talking about, advocacy officers. And then, of course, we've got legal officers up to senior legal officers. One can go all the way to become a provincial manager. One can go all the way to be the head of legal services unit. We've got a legal services unit, and we've got other units, as I said. So it's a very diverse career opportunity at the Human Rights Commission. The first question was a very important question. Do we have the powers to dismantle structural causes of human rights violations? Let me start by being honest to say the majority of our work is reactive, reacting to complaints that we receive from the public. And I'm fine with that because the Human Rights Commission was created to be an easy vehicle for access to justice. Therefore, members of the public should be able to come to us and raise concerns. So we don't claim to know everything in terms of what's happening on the ground. So the majority, as I said, 7,000 complaints from the public. Where we deem the matter to be systemic, then we institute inquiries or hearings to go to the root cause of the issues. Next week, we'll be releasing a 5-year reflection on the 2021 unrest. You will recall the 2021 unrest where more than 350 people died. As a Human Rights Commission, we did institute an inquiry. Now, 5 years later, we are looking at the question, has society learned any lessons from the root causes of that event? It was not just the arrest of a former president. There were key structural causes that led to the arrest, to that unrest. So we do that. But as I said in my presentation, we also focus on proactively. To your question, are we also proactive? This report that I spoke to, the promotion of a culture of human rights through the resolution of the national question. It's a campaign my office started last year in March, even before the talk of the national dialogue, because we are concerned that, yes, we can attend to individual complaints, but unless we go to the root causes, issues of redress, reparation, restitution, then we'll be only focusing on symptoms of systemic human rights violation. The last example that I can give is that we have made a call for submissions on data centers, which is a very new phenomenon in South Africa. The setting up of huge centers, technology centers, data centers. And we are saying we are opening calls for submissions on the human rights impact, the use of electricity, the use of water, the use of space. So that is an endeavor to be proactive on an emerging issue in society. Thank you.
Thank you very much. By the powers vested upon me, I'm going to switch things a bit so that we finish on time, but we cover everything and we address all your questions. I am going to request our panelists here to take seats. We're going to call the next panel, but before then, I'm going to ask Judge Lester Nuku to come and give us words of encouragement, followed by Prof Thuli Madonsela with the remarks. Thank you. Tim?
Thank you, Program Director. Can you hear me?
Yes, you are audible.
All right. Deputy Minister of Justice and Constitutional Development, Mr. Andries Nel, Professor Pienaar, Professor Madonsela, and let me take this opportunity to greet everybody who is here present this afternoon. It is always for me a great pleasure to talk to the law students because it reminds me of my time when I was a law student. I can confess that I probably completed my law degree without seeing a judge in person or a minister in person. I knew them through the law reports. And that kind of knowing the judges can be intimidating, and you think to yourself, is this something that is humanly possible? Do I have what it takes to be that person? So in order to make that point, I thought I was going to speak a little bit about integrity. I think that topic has been covered. Integrity is non-negotiable. Period. Without integrity, if you're thinking of pursuing a career in law, forget. You are gone. I thought I was also going to speak about the hard work, but Advocate Gordon Turner SC covered that in the words that she used, that hard work beats talent if talent doesn't work. That is so true. Talent only gets you to the starting line, and then it is the hard work that carries you through. But then back to the issue of seeing judges through the law reports. I am currently acting as a judge of the Constitutional Court. Prior to that, I've acted at the Supreme Court of Appeal. I am a permanent member of the Western Cape High Court. I am a permanent member of the Competition Appeal Court. Those accolades, if you look at them, it will be like, wow. But, but that is something that comes from an ordinary human being. I failed Standard 3 when I was still a student, a learner. But I carried on, I was not mature. After I finished university, I spent the whole year sitting at home without getting articles or any sort of employment. It got to a point where one of our neighbors who had never been to school began to question the value of he could not differentiate between high school or any form of education. So he thought that with my university degree, I had a matric. So he says to me, well, what's the use of this matric? He couldn't even say matric proper. He says, this matic that you have. But I had this university degree, and so I'm telling the story to say that you will graduate, you will have ambitions to be placed at the top 5 law firms. Some of you will be fortunate to get that, but not all of you. Some of you will be placed at firms or companies that they would rather not be at. That's just how life is. It's not the end of it. So after spending that whole year at home without any form of employment, my father then got me articles at one of the Eastern Cape rural towns in Engel. And so I started my articles there. And I had a principal who was, who cared about his candidate attorneys, who told me that his practice was not such that it could prepare me to pass the board examination. And so he recommended that I go to the School for Legal Practice. That is how I ended up in Cape Town. I then applied to come to Cape Town. So that part of the story is to say, it is not about where you start. Where you start is only the beginning, and it's never going to define where you end up in life. I then came to, so I did those articles. I then came to the School for Legal Practice. I then, when I was in Cape Town, got offered articles in a medium-sized law firm. And with his blessing, I then terminated my articles with him. I couldn't see them at that time because that part of South Africa was called Transkei. It was governed by a certain set of statutes, so I had to start afresh. Someone who had attended who had that course from the School for Legal Practice was entitled to a discount of a year when doing articles. But because at that time I didn't have Afrikaans, which was a requirement in the Republic of South Africa, my articles had to be 3 years, despite others having to have discount. So I registered my articles for 3 years. But I was fortunate that in that year, then there was an amendment to the Attorneys Act, which did away with the requirement for Afrikaans, and I then got the discount. I then completed my articles, and then at the law firm where I was doing my articles, there was a number of candidate attorneys. I was not the only one. And I could see that some of them had prospects within the law firm. And one day we were having the final year function, year-end function, and one of the directors, who I thought would be the one offering me an opportunity to stay at the law firm, asks me, Lister, what are you going to do next year? And so I had to quickly dream up a story that now I'm going to go back to the Eastern Cape to do this, this, and that. I had no idea what was going to happen to me. But fortunately, I was able to find something in the Eastern Cape where I worked for about 6 months, and I think in month 4 or 5, I was paid half a salary, and it became intolerable, and I was told that I must leave, and I came back to Cape Town. Back in Cape Town, I stayed for, I think, about 2.5 or so years. Then I started practice. I joined 2 fellows who had started the practice. And when we started, I think the competition tribunal was running seminars around the country. We got interested in that. We attended those seminars. We had big dreams of becoming these competition lawyers, because Competition Act had just been put into operation, so we thought there can't be anyone who can claim to have a specialization in respect of that area. So we tried our luck, and we almost got clients, but they thought they must put us to a test. I was asked about this form that you use when you refer a large measure to the Commission for approval. And I ran quickly to the government printers to get that form so that I could send to my client, but the potential client realized that if this fella is going to fax it to me, that time emails had started coming in, they were in use, but not all of us knew what was going on. So he expected me to quickly email it to him, but I couldn't. But despite all of that, it so happened that I did end up in that court as a judge, as a permanent member of that court. So I'm telling these anecdotes to say to you that you will graduate with your law qualifications. The road is not going to be easy. I am certain that even where you are today, you have had circumstances that you have had to deal with and overcome. It shall continue to be like that, but you must keep on. All you have to do is to show up and remember that hard work beats talent. I usually say hard work beats talent every day. But I can accept that talent beats hard work when talent doesn't work. So with those few words, I wish all of the law students that are here all the best in the future. When the going gets tough, you must remember it is not the end of the world. It is just a chapter in your life. And as the chapters, they come and they go, and you keep on going on. You never know what is destined for you. But all that you have to do is to put on shoulder to the wheel on the task that you have at hand at that particular point in time, because the universe notices. With those words, I thank you very much.
Thank you so much, Judge Mugu. I think these are the stories of resilience, ne? And positive attitude. While Prof is coming to the podium, I'm going to request the 3 law firms. I said by powers vested upon me, I hereby flip the program around. Bowman's attorney to come and take the podium, and then Nkotla attorneys, and ENS Africa. Can they just come and get seated over here?
Thank you, Program Director. My apology for being the reason you had to make me jump the queue. I do need to go somewhere. Greetings, everyone, and a special greeting to our leaders, Department of Justice, the Judiciary, the profession, and of course, our honored guests, the young people who want to join the noble profession. You do know that you're joining a profession that never lies. You probably have heard a story about a lawyer who couldn't lie because lawyers do not lie. So he had a wife and 12 children and was looking for accommodation. And every time he tried to get accommodation, once they asked about how many children do you have, he would tell them that he has 12 children and that was tickets for him. So the next time he went to view a house, he asked his wife and all his children, except one, to go to the cemetery. And then he went, viewed the house, and as he viewed the house, then they asked him, how many children do you have? And already they liked him and they thought they were going to give him the house to rent. And he said, 12 children. And the estate agent then asked, where are the other children? And he said, at the cemetery with their mother. I'm starting with this as a joke, but primarily because when you're entering the legal profession, which by being law students, you've already entered or started entering the legal profession, you will be shaping the world. And sometimes convenience determines what you do as a lawyer. And on the face of it, this lawyer didn't lie. But by giving an impression, he made them believe what was not true. In my remaining 7 minutes, because I do have 10 minutes, I'm going to focus my remarks on what I say is we need transformative lawyering as leadership for a just society and world. I'm doing so because the Deputy Minister of Justice, long-term friend, Andries Nel, our acting Justice at the Constitutional Court, our Dean and colleagues from the bar have all outlined to you what do you need to enter the profession and to succeed. And therefore, I don't want to go there. I have only two things I want to talk to you about. One is why you should enter the public service as lawyers. The other one is lawyering is leadership, and I'm asking you to do it transformatively because we get the world we deserve, and the world we deserve is the one we help shape through everything we do every day. We could be like that lawyer and use a loophole. Or we could be a different one that is not going to use loopholes, but use the Constitution as a North Star, Universal Declaration as our North Star, Sustainable Development Goals as our North Star, to shape the world we want to live in and the one we want to leave to our children. 2 days ago, we celebrated the multifaceted contributions of one of South Africa's finest lawyers, Nelson Mandela. And his achievements as a lawyer and his acts that amounted to lawyering as leadership were not just in the courtroom. they also included outside there, which says, with your law degree, yes, you have a multitude of things you're going to be able to do, but there are other things that you're going to do that are not necessarily part of the legal profession. So it holds you in a good position to do a whole lot of things. You know, one of the most famous people in this country who has spoken on economics was Ben Turok. And I only discovered he wasn't an economist when I had to speak at his funeral. So with a degree, you're given tools to understand life, to analyze things, and with further studying, as colleagues have said, you can shape the world in various places. So the first thing I say to you, I'm going to talk about the public service. Many people think you go to the public service when there's nowhere else to go. I believe that the greatest shaping of society happens in the public service, from school governing boards right to the presidency. And if you have a view on what should society be like, then you have to enter the public service. And the Deputy Minister and our colleague from the LPC have all indicated what opportunities are there in the public service as a lawyer. So the starting point might be to enter the public service as a lawyer. Mandela, whom we celebrate, entered the legal profession for justice and equality, and we heard that on Mandela Day. I had in my dormitory a sketch I had done on him, and I also had these words he said during the Rivonia trial. During my lifetime, I've dedicated myself to the struggle of the African people. I fought against white domination and fought against black domination. I've cherished the ideal of a democratic and free society in which all persons live together in harmony and with equal opportunities. It is an ideal which I hope to live for and to achieve, but if needs be, an ideal for which I am prepared to die. What ideal do you live for? And after today, when we break the four walls and we go back to where we came from, what ideal do you want to live for? When you get your law degree and you take your next step, to what ideal will you be practicing with your law degree, regardless of which direction you take? One of my favorite sayings is that every generation has an opportunity and responsibility to improve its situation and leave a better legacy for future generations. People often confuse that with Frantz Fanon's iconic quote that says, each generation must, out of obscurity, discover its mission, fulfill it, or betray it. We're in this room multi-generationally. I'm the higher end of generations. There are people in the middle, and many of you are in your teens, or at least early 20s. Truth must be told is that no generation shapes the world on its own. Yesterday, at the finals of the World Cup, we experienced a visual representation of overlapping generational impact and glory between two generations. On the one side, the winning team, we had 19-year-old Yamal, and on the other side, 39-year-old Messi. But they were tied by fate. Messi had an opportunity when Yamal was a baby to hold him, to bathe him, and there, life brought them together. For us, when we drafted the Constitution, I was fortunate to be part of people who conceptualized some of the ideas that ended up in the Constitution, one of them being the substantive notion of equalities. So people are lying to you when they say the Constitution came out of the back of somebody's pocket. It was ideas that we had been thinking about, and it was ideas that the ANC had been thinking about. It was ideas that the apartheid government had also been thinking about. So it was a collection of ideas. But intergenerationally, we came in with Prof Sandy and others as the 11 core technical experts that were helping with the drafting of the Constitution. But among us, there were people in their 70s, 80s, and we were in our 20s and some in the 30s. So in so doing, I just want to endorse what has been said by, I think, Deputy Minister and everyone else, that you're never too young to lead. So where are the future opportunities in law where you can lead? I have indicated that there are two things I would like you to do. One is join the public service. So I'm going to emphasize the public service. That includes, the public sector. That includes being a judge. So Prof Vim had hoped that the Stellenbosch University would, in his leadership, also produce somebody who goes to court. But we're glad that we have judges that have been part of Stellenbosch University that are in court. Prof Diresh also hopes that the transformation work that they're doing here could land in the benches. But for you as young people, the idea is not to leapfrog into, oh, I want to be a judge. And I like the way the Department of Justice has shaped this conversation, that it starts with, where do you start? Candidate attorney, having an opportunity to be mentored as an advocate, and then right until the day you can become a judge. So I don't want to deal with what opportunities are there in the private sector, because that has been dealt with extensively. I want to say, though, increasingly there is the ombudsman institution. So if you are going into law, think about a growing sector globally, not just in South Africa, globally, the opportunity to be an ombudsman. So you have an opportunity. The public protector is an ombudsman-styled institution, but there are other ombudsmen, like the tax ombudsman, the military ombud, the health ombud, etc. So that's also an opportunity for you to enter. Even universities have them, local government institutions have them. And these are, I'm mentioning this one sector where transformative lawyering is extremely important. So what is transformative lawyering? It's lawyering where you use your law skills not to cement inequalities and injustices. You use your law skills to bridge the gap between law and justice. And in Makwanyane and in many speeches by Chief Justice Ismail Mohammed and Dala Omar, the First Minister of Justice and Democracy, you will hear that they were concerned about the fact that we inherited a society where law was primarily an instrument of injustice. And therefore, as we've traversed the journey into democratic South Africa, we've needed to bridge that gap. So wherever you decide to go, I'm asking you to bridge that gap, and that has to be done through transformative lawyering. But how do you decide where you can best serve as a lawyer? First thing is, think about what are your talents and what bothers you most. So when you choose that. But I want to say it's possible, though, that you might not be able to go where you want to go. So 2 suggestions there. Number one, if, for example, you would like to be a human rights lawyer, but you can only find a job as a prosecutor. Take it. And then you can do your human rights lawyering as part of your voluntary work, volunteering work, not just volunteering on the 18th of July, volunteer throughout the year. How I got into practice personally, for example, I started on a holiday job at the National Union of Printers and did labor law there. But the interesting thing is that whilst I was there, I also met two shop stewards whose brothers were on the death row. And when they spoke to me about what happened, and clearly the brothers were not there, it was common purpose principle. With my very junior knowledge of the law, I went to Priscilla Jana and said, I think these young people were wrongly convicted. The short story is, she took the case and those young people were saved from the death row. So in Africa, we say you're never too small to make a difference. And if you think you are too small to make a difference, you've never been in a room with a mosquito, with closed windows and doors. Lastly then, so transformative lawyering would be the kind of lawyering that ensures fairness to all, and that would include social justice. I'm going to send you this paper. I just want to say, what kind of justice consciousness do you need to do transformative lawyering as my last but course? I think you need 5th level justice consciousness, especially if you're going to be a lawyer in the public sector, because you are entrusted with people's power. And you exercise enormous power there. I mean, but even as an advocate, you exercise enormous power because whatever you say is the right thing to do, people will go with you. Now, what is 5th level justice consciousness? It's a kind of justice consciousness that understands that it's okay to think about justice for yourself. It's okay to think about justice for people like you, which at the Department of Justice we used to refer to as justice is just us. It's okay to think about justice for all, but you must also understand that everything has justice implications. Everything, including corruption and fraud, has justice implications. If you engage in corruption, you're unjust. If you engage in fraud, you're unjust. If you allow that to happen, whether as a lawyer helping them or as an adjudicator who looks the other way, you are enabling injustice. But secondly, you need to be a lawyer that understands that everyone must act justly. It was Eleanor Roosevelt who said, if we want to see these human rights being enjoyed by everyone, then we must make sure that they are felt everywhere, in homes, in factories, in all the ordinary places. Because if they're not felt in the ordinary places, we'll look for them in the big places and will not find them. So why am I raising this as my parting shot, colleagues? Is injustice happens in the little corners. And your generation, my dear young friends, likes canceling people. Now, if you're canceling people, you're creating echo chambers. If we're saying, if we want a just world, everyone has to act justly, fairness to all, including socially just behavior, then the ones who are pushing into little corners are regrouping in ignorance, and they continue to act unjustly. But also they start thinking, oh, whoever is in power can act unjustly. Because when we start being mean to them, that on its own is being unjust. I'm not going to talk about what happened in the past. I'm just going to say, how do we act justly, consistently? People have already said we must embrace Ubuntu. And I say must, it's not a may, because as Mrs. Makwanyane said, Ubuntu, the Ubuntu value system is part of our foundational value system. And more recently, in a groundbreaking case, the Constitutional Court affirmed the same thing. And it said the following. This is Greater Zanin Municipality versus Bravo Span. And that case was decided last year. The court said, the Constitutional Court said, a central value this court has previously identified with which public authorities must comply is Ubuntu. An ethic of Ubuntu is inconsistent with taking advantage of others and requires conduct that involves treating everyone with whom one comes into contact with utmost respect in all interactions. And this is particularly important in the relationship between government and its citizens. So, my dear young colleagues, congratulations on choosing law. It is a profession that is not supposed to lie, but there are people among us who lie in a very sophisticated way, like the case I told you when we start. Now, if you lie, though, you can succeed to deceive people some of the time, but you can't deceive them all the time. But for me, that's not the most important thing that matters, whether you're going to be caught or not. What matters, and my message to you is, we are in a world that is increasingly unequal, a world that is increasingly angry, and as lawyers, you have the power and opportunity to shape that world. Now, will you shape it in such a way that it's a more humane, honest, and fair world? As people like Mandela, Priscilla Jana, Bram Fisher, Pixley Gaseme, and our generation tried to do? Or will you find yourself finding loopholes to get short-term victories, but whilst creating a systemically unjust and unequal world? I do believe that based on what we've heard today, and the fact that you came today, you are going to be the transformative lawyers we've been looking for. Good luck.
Thank you. While you're still standing, I know that you need to leave at 2, so I'm just going to request that you hand over the gifts that you intended to the judge and to the DM. I can't see the photographer, Jan. Okay. Judge Nuku, can you just, DM, if you can be here so that you can be captured correctly. In front of the podium. And smile. Thank you. Judge Nuku? Oh, yes.
Thank you. Oh my God. Actually, I am worried that the last time I gave DM a we haven't transcended our history of giving people, of paying people with the tort system. But this time, this is part of the economic system in this community, and it benefits all of the people. So thank you, sir, and thank you for telling your wonderful story. Your wonderful story is actually similar to Madiba. His experience at Wits was as horrendous as yours, but look what became of him.
Thank you, thank you. Thank you. Yes, you can. I'm going to give to the law firms. Immediately when they're done, just pack your questions. We're going to take the next panel, right, which will be talking about the careers, and we'll wrap up with a set of questions. I'll start with Bowman's. And I know that you need to leave. I requested that you leave the contact details of the talent manager at your firm, so that most of the questions that you might not take here, our students know where to direct them, right? Thank you.
That is fine. Good afternoon, everyone. My name is Xolani Nyali. I'm a partner at Bowman's in the competition law practice in Cape Town. And I've been with the firm my entire working career, other than 1 year in Brussels. I had the privilege of working out Freshfields. So I'm here to talk to you about the firm and what we do, and you know, I'm here with my colleagues from ENS. We're in a fierce battle for talent because in the professional services, obviously, the human talent is what we sell, right? We can't service clients, we can't provide the services we do without talent, and we're always looking for the best talent. So with that in mind, I just want to start at the end, which is, you know, we always keen to invite learners from high school and university to come visit us. We have job shadow programs, VAC work programs, and obviously the article clerk program. We also have bursaries. I sit actually as chair of our bursary committee. I sit as deputy chair of our graduate recruitment committee. So it's a pity that I can't stay for very long to engage with you in those capacities, but I will leave the details for our grad team. So if you're looking either for a bursary or you want to come visit us, do please reach out. Certainly, our thing as a firm is that financial need should never be a barrier for people to come into our profession, and we do what we can to make sure that is not the case. So Bowman's, I think we can go to the second slide. Okay, I think we can just stay on this slide. So Bowman's is a Pan-African law firm. I must confess, I haven't had to think about the firm in South African terms in the longest period, because we are proud to be an African firm. We've got offices in 6 different countries, but obviously all started here in South Africa. We've got 3 offices in Cape Town, Johannesburg, and Durban. We've got offices in Nairobi, where I've worked for a year. We've got offices in Dar es Salaam, Tanzania, Mocha in Mauritius, Lusaka in Zambia. Which one am I leaving out? And then we've got alliance firms in Ethiopia as well as in Nigeria. What this presents for law students who are coming to the profession is this amazing sort of firm where you get to work and operate across the continent. Yeah. If I look at my work as a competition lawyer, I would say about 60% of the work I do is outside of South Africa. 40% is in South Africa. And that really, I think, is business, because we are ultimately advising multinational corporations or South African businesses that have grown to the level of expanding across the continent in different areas, whether it be competition, tax, banking and finance, shipping, you name it. But business doesn't do borders anymore, right? And so we follow our clients wherever they go. And so for young lawyers, you know, and all you need is your LLB, right? We were talking about earlier. But South Africa is definitely not just the market that you'll be operating in. And if you're worried about AI, and we all are investing heavily in artificial intelligence, we use Legora, we use Harvey. And then, I don't know what that thing is called, Copilot. I don't use that one. But what we're very clear on is that AI will not replace lawyers. But lawyers who are proficient in AI will replace lawyers who aren't, right? And so it is absolutely important for young lawyers to be proficient in AI, and to that end, we actually have an in-house academy for young lawyers who come in and want to explore that aspect of how to deliver legal services. We've got a whole team where you can play around, right? Write code, look at our legal processes, how we give advice, and improve our processes. That's part of it. It's all quite exciting. I'm too old to learn most of these things. I'm about to turn 40, so can't do all of those things. I think if we can go to the next slide. Sorry, I'm rushing through this. No, oh, that's it. Sorry. No, let's go back then. I thought I had a slide there which reflects all of the different practice areas that we have. So the firm is split into 3 departments: disputes, corporate, banking, and finance. Underneath each of those 3 departments sit 16 different specialist areas. So when you come to join the firm, you will rotate, because our system is one of rotation, and I think you'll hear from ENS, theirs they do not rotate. But as an article clerk, you spend 6 months in different practice areas, and we hope that at the end of your 2-year rotation, you will have selected one of them, right? You will have fallen in love with one of them. Because most of us come into the workplace thinking we will enjoy one type of law, and then we find out that we don't. I thought I was going to be a banking and finance lawyer. I hated banking and finance. I still do. I think it's just high-class conveyancing. But whereas there's other things that are a lot more fun, right? But conveyancers will kill me for what I've just said, because they genuinely enjoy that. I don't, right? And so, but you've got all of this multiplicity of areas of practice, including ones that didn't exist a couple of years ago, right? So for example, Judge Nuku was talking about competition law 1998. It didn't exist before then, now it's there. Data privacy didn't exist until 5 years ago, it's now there, right? So there's all these new areas of law that are coming up. And so we don't know what other areas of law will exist by the time you guys come into the profession. But whatever it is, to the extent that you are doing incredibly well in your studies, and we hope you are applying yourself, because without you doing incredibly well, so this is, B average upwards, back yourself, right? Because that gives you opportunities to go wherever you want to go, including in the Big 5 in South Africa. Reach out to us. We're always willing to have the conversation. We're always looking out for talent. And yeah, let's hope we can partner together and create the next phase of Bowman's. Thank you.
Thank you very much, Kolani. The contact details, I'll announce them. Bursaries, you had job shadowing, and so on. Let me call ENS, and then we'll end with Nkotla. Thank you.
Okay. Good afternoon, everyone. See, the presentation is already up. We are so grateful and honored to be here today as part of this very important initiative. My name is Tanisha Vaswani. I'm here with my colleague Yumna Idris. We are both from ENS, both part of the Pro Bono team. I'm an associate in the Pro Bono team and also the Pro Bono coordinator for Cape Town. We are here on behalf of ENS to present a bit more on who are we as ENS as a law firm, and a bit more about the application process if you are interested. So if we can please go to the next slide. ENS is a firm that offers specialized legal services. So we have very specialized departments, and using these specialized departments and the experience and the expertise gained through that, we try to give the most tailor-made solutions for clients. We advise on a broad range of matters. It might be in-country, it might be cross-border transactions. Often at times, we might need to collaborate with external providers. So we've got a very, very good network in order to give clients, really the best solution for their problems. If we can go to the next slide, please. Awesome. So who is ENS? You might have heard us say this often, but we are one of, if not the largest law firm in Africa. We have got many, many different offices all across Africa. We are also very, very proud to be African. So we have got an office in South Africa. We've got one in Cape Town and Stellenbosch, in Johannesburg, Durban, as well as Mauritius, Namibia, Uganda, Rwanda, Kenya, and Ghana. And we've also got 2 dedicated pro bono offices where we receive walk-in clients. We've got one in Mitchells Plain that serves Mitchells Plain and Khayelitsha, and also Stellenbosch. And we've got one in Alex in Johannesburg. So on the slide is a list of all the specialist areas. Without repeating all of them, there is a broad range. It's things like competition, dispute resolution, so litigation, employment, it could be forensics, although forensics is out of the legal practice, insolvency, intellectual property, shipping, banking and finance, tax, mining, for example, project finance has become very much more busy recently with all the renewable energy projects coming about. Okay, and then the next slide. So what are our values as practitioners in ENS? Number 1, to always do the right thing. So it's so important to be an ethical attorney and to always do the right thing, no matter how difficult it is. Number 2, to put people first. Law is a very people-focused job. You have to care about your clients, about doing the best for them. You have to care about your colleagues, about your team, and doing what's in the best interest of your team. Number 3, to recognize diversity. I'm very proud to say that ENS is one of those firms that doesn't talk diversity but actually does practice it. So recognizing diversities is very, very important. Number 4, to be exceptional. To really, really extend yourself, apply yourself so that the client does get the best solution possible. For those of you who are interested, a question that ENS gets asked a lot is, what do I have to be or what do I have to show in interviews, in order to get the highest chances of succeeding? So the things that they are looking for it's a mixture. It's diligence, how hard can you work? How do you have good attention to detail? And they'll look at that through, your academic performance. Are your grades strong? Your general standard of productivity, are you someone who can work hard? And again, they will look at your academic performance. Research skills, they can look at your grades, but they can also ask you questions in the interview, to test, your sort of thinking process. Are you an analytical person? Do you have a broad knowledge of the law? People skills. So a question I think they get asked a lot is, how do I show that I have people skills to ENS in interviews? And a really great way to show that is if you've been part of extracurriculars, so student organizations, where you've either worked in a team or your organization has dealt with sponsors, vendors, any third parties. Those are, great, easy ways to show that, 1, you can work in a team, and 2, if you've got experience with third parties, that you can work with clients. And lastly, administrative skills. So if you've got a nice way of showing that you have administrative skills, that you are able to juggle a lot of things, is if you can show in your CV that, in addition to my academics, I also balanced this, or I also juggled this. Because when you come to articles, you'll find that you'll be dealing with so many matters, and you'll have to get good organizational skills. So what are the opportunities we have? You might know some of these. We offer a winter and a summer vacation program. During this vacation program, you will get written assignments, you'll get a chance to do a moot court, to practice your mooting skills. You will get a chance to spend time in departments, so with actual teams, and you'll rotate. So you'll actually get to see firsthand, what are the teams like, what matters are they working on. And then that vacation program, it often ends in a final interview with HR. So you essentially get a chance to, have that interview with HR, and if successful, then they'll sign you on for articles. So articles, as our colleague from Bowman's mentioned, at ENS we have a non-rotation policy. So when you are signed for articles and you are selected for a department, you stay in that department for 2 years. And the reasoning behind that is really to ensure that after those 2 years, you have gained as much expertise in that field as possible, and you've integrated into the team. During your articles, there's also a lot of resources, that I myself was also very privileged to get during my articles. So there's lots of support that's given when you're writing your board exams, in terms of those kind of resources, as well as there's counseling sessions, to manage the transition in the beginning. So there's a lot of really, really great supportive resources that ENS does provide when you are starting out. Lastly, very similar to Bowman's, we do offer bursaries. So if you're assigned for ENS, if you've gotten accepted into ENS, and you're struggling with accommodation, fees, textbooks, reach out, because you'll definitely be eligible, and ENS can consider consider you for a bursary. Okay, so these are some of the opportunities we have on at the moment for the CLP program. They're taking in applications for 2028 for Joburg and Cape Town. There's also a summer vacation program, but that is opening on 1st of August 2026. So if you want to take a note of that, you can start applying. The next slide, it shows one of the ways in which you could get recruited into ENS. So, for example, if you apply for the vacation work program that's coming up, they will consider all the applicants, and then their shortlisted applicants, they will send you an email with links to psychometric tests. So these are tests just to check your aptitude, just to check your personality. And if you pass those, then you get into a round of interview with HR. It could be a first and a second interview with HR. Following that, if that's successful, you get an offer to do the vacation work program. You do the vacation work program, you get your final interview at the end, and if that's successful, then you can be signed into ENS for your articles. Okay, in order to apply, this website is very important, so this link is posted up on the slide. They only accept online applications. And if you have any questions, of course, then you can send it to graduates@ensafrica.com. So, all right, shame, this must be a lot of information, but definitely feel free to reach out to that email address if you are still confused. We have also brought some. So it's not the end of our presentation yet. We have one more thing coming up, but we have also brought some books and some pens for you guys. We do have a limited stock, so at the end of the event, we will be at the back to hand out if you still have more questions. So I mentioned at the beginning that we have 2 dedicated pro bono officers, and I've spoken a lot about what our corporate officers do. For the next part, my colleague Yumna Idris will be coming up. She's going to speak to you a bit more about our pro bono department and what a day in the life would look like if you were a CA in our pro bono department.
Good afternoon, everyone. I'm going to keep it short and sweet because my colleague has covered a lot of the topics. So we are going to focus on the pro bono aspect because we are speaking about access to justice. And even if you are in the private sector, you can still assist on a pro bono basis. So like Tanisha mentioned, we do have 2 satellite offices that focus solely on pro bono matters. And so what that means is we have 4 legs or 4 branches of this pro bono office. Number 1, we have enterprise development. So that is SSME. So there's any small businesses that need maybe assistance with tax compliance, registering their business, or it could be as simple as how do you draft a employee contract? If there's a CCMA matter that's happening, how do you assist? Because one thing about the law is it can be quite pricey, so we try and assist with bringing the resources to people who need it. Another aspect is legal education. So we have seminars and workshops within high schools and schools, and it can be as simple as what is a right and what are rights and responsibilities to the Bella Act has now been amended. What does that mean for teachers? So we would go in and have seminars with the teachers. We also have individual legal assistance. So majority of our attorneys, both in Alex and in Cape Town, they have a dedicated pro bono day where they come in and they consult with walk-in clients. And the matters could be a will, it could be an estate, it could be a company matter. But depending on what the matter is, we will try and assign a specialist that can assist you with that matter. We also assist with divorces, domestic violence, abuse of children. And if we are not able to assist, we do reach out to the Cape Bar for pro bono assistance. And so we are frenemies, but I'll say we're more friends than anything else, because I've worked with them on a few matters, and they're quite quick to send me an email back when I might not be able to assist. And then we also do strategic litigation. So I don't know if you guys have heard about the Truth and Reconciliation inquest that's been happening. ENS does assist with a few of them. And then if the Human Rights Commission has a matter that they need assistance with, we also do try and render them a service. And then the last thing I want to mention that ENS pro bono department does is, I'm not sure if you guys, well, I'm sure you guys have heard about the small claims court. So any claims that are below 20,000, in order to assist with access to justice, we have this remedy. So majority of our execs sit as commissioners of the small claims court. And then that's in a nutshell what we do, because we do believe in a grassroots approach. And while we do walk-in clients, we also have bigger matters where maybe a hospital per se is re-looking at the trust, and they maybe need assistance with re-looking at the constitution. And they'll bring that matter to us, and we'll see how we can assist. And then our execs will assist them on a pro bono basis. So there are opportunities within the corporate space to do access to justice and pro bono. And you're most welcome to reach out to us if you have any further assistance, because I know this is a bit of a new stream that has now entered the space, but we are keen to listen to your ideas and also answer as many questions as possible. So we'll be in front if you are looking for any assistance. Okay, thank you.
Thank you so much. Let's take the last speaker for this panel, Mr. Mzimasi Mayeza from Nkotla Attorneys. You will see we try to mix the law firms, right? Small, medium, big, in that way. But there are opportunities everywhere. We're just trying to show you that opportunities everywhere.
Yes, thank you so much for the opening remarks that you've just done for me. That's what I wanted to start with, and also I think most of what I would have wanted to start or say has already been said, and I thank the blessing that Justice Nugu came before me, because he paved the way for us, saying that, because if he's saying he comes from, if he started at a firm that is based in Engcobo, we are more like based in the same way because our firms are focused in the townships. So we make sure that that's one thing that we do not change from, even if the firm grows, we do not leave the township. If we move to another area, we look for the township. Greetings, my name is Mzima Simayeza. I'm also in the company of my colleague Okwehle Msinga. We come from Ngotla and Partners Incorporated. It was formerly Ngotla Attorneys. I want to first start by saying I'm so proud of you for taking the time to come here. Being a law student, practicing law, it's all about rising to the occasion. Every day when you wake up with what legal problems do I have to solve today? Whose solution am I going to be today? So I want to say, and after I say this statement, I want you guys to give yourselves a very big round of applause. Looking at you, I can safely say that the jurisprudence of the Republic of South Africa is in great hands. Give yourself a round of applause. Thank you, thank you, thank you. Please allow me to keep this bottle here. I have a very shallow voice, so if it fades away, please just know that I'm still with you here. I'm not leaving. We are Ngotla and Partners Inc. It is a 100% black-owned law firm. We are fully based in the township. The law firm is based in Khayelitsha. We have 2 offices in Khayelitsha. So we had to open another office in a nicer part of Khayelitsha because the other one is based in an environment where if you go coming from outside Khayelitsha, you may not feel comfortable. So we have clients that are coming from outside Khayelitsha. So we decided, let's look at the better part of Khayelitsha and have an office there so that we can accommodate those. But we have one where it's not that easy to access. If you're coming from outside, you have to first know the areas which way and where not to go or where to be vigilant if you go. And we have the second one that is based in the Eastern Cape. It's in Uitenhage. It's also in a township, KwaNobuhle. So we are fully based in the township. Our services are tailored for the people that are in the township. So mostly another thing that you want to provide when you are in the township or when you are practicing law, it's pro bono work. We always preach, especially in considering today's celebration, the spirit of Nelson Mandela, the spirit of Ubuntu, humanity and giving back to the community. So in as much as we are a law firm, it is our everyday thing to give back to the community. We pride ourselves on that, and also we consider ourselves to be there for the people that are unable to move to urban areas if they want to access legal services. We make sure that we provide the best legal services, and we make sure that the legal services that the people get, they are the services that when they look at the TV, they can identify with those services, say, oh, we also get those at this law firm that is just in our neighborhood. So we want to provide them with services that will allow them to know that they have a legal firm in their present, in their immediate surroundings. Our practice areas, we do most of conveyancing work based in the township, so there's mostly conveyancing work, and we are one of the biggest firms in the township that we're in that are doing conveyancing work, and we pride ourselves in that. We also do a lot of family law, and when we do family law, that's when you realize that most of it will come as pro bono. Just recently, we had a client, a very old lady. She's a pensioner, but she's still working as a domestic worker. She came to our offices just recently saying that I've just started a divorce with my husband. We have been married for 33 years, and in that 33 years, I do not know a cent from him. I have built a home for my children. All I know is physical abuse from him. And now what broke the camel's back was when we have a daughter that is married. Now the daughter has come back to stay with us because she's having issues with her in-laws. Now he was fighting with me, saying that she should go back and be a wife at her in-laws, regardless of how the environment is. She then said, opened my eyes to say that I've been subjected to this for so long. Now my children are going to be subjected to this. I want a divorce. In fact, she even went as far as fighting with him and assaulting him. He went to open a case. Then she said, I then realized that I've been in this marriage for too long, a very toxic one at that. Then she did not have the funds, obviously. We said, Mama, we're going to take your case. And when we started with the divorce, we finally came to learn that the husband has resigned from work, and we had to now go and interdict the pension fund. So those are the services that you know, for someone, a regular person in the township, they can't easily access the Rule 43 benefits of having to claim maintenance from their husband. So it's the services that we make sure that we tailor for our clients. So when you go to firms like ours, you need to be in the spirit of serving the people. In as much as we are happy to receive fees from clients, but we also do not turn a blind eye when we see a cry for help and a need for a client's help. So we also focus on admin of deceased estates. Even in that one, we tailor our services very well to fit the communities that we are in. And also, with working in the communities, you must be able to interpret the legal principles, to provide the legal services in a sense and manner that those people, they would understand. For instance, you will meet a case where the family comes saying that the mother and her child has been involved in an accident. They want assistance with reporting the estate. You report the estate to the master's office, and then you get told that because the mother was unmarried and she died with her children, they want the father of the children to inherit, to report the estate and inherit. Then now you have to go back to that family who do not even understand the English language and explain to them that, no, the father of your daughter's kids, who was not even supporting them, is supposed to inherit her estate. Now you need to interpret and explain to them how the law works and how can you be able to assist them if they provide you with what information. So we live with those realities of the people who, in as much as they cannot understand how most of the legal work, of the legal principles work, but they still are subjected to that. So you need to provide a service to them. We also do a lot of civil work. We provide civil service, both civil litigation in the High Court and in the Magistrate Court. So we are also there. I don't think there is much that I'm going to say. I will end it there. Thank you, sir. Thank you.
Thank you. Thank you very much. I'm going to request, as you move from the podium, we're going to take questions afterwards, right? So I'm just going to merge these two panels in terms of questions. So you may take your seats. Then I'm going to request the NPA, Advocate Renee Ace, and Mr. Pumezo Qalile from Legal Aid South Africa, as well as Mr. Mukulubete. I can't see him, from the Department of Justice, and Mr. Sisa Mangele from the Public Protector. So please don't eat into each other's time. Ne? I'm giving Public Protector, we agreed 7 minutes, long time ago. And then, yeah, you'll be fine, all of you. Okay, in that order. I wanted to, I wanted to ask this question. It's a very interesting one because I always like to tease the legal students. Who is the first public protector in the new South African democratic dispensation? You all don't know. There's a hand there. I see Google works. The new public protector post elections, you don't know? Okay. None of you knows. Okay. While you are still coming back to it, Who was the first Chief Justice? I think it's important that we do this kind of things because you cannot study law and don't know those who came before you. Over to you, sir. Which one are you answering? The Chief Justice one. Yes. It's a tricky one, that one. If you get it right.
The problem is that there's technically two answers. So
just stand up, yes.
Oh, there's technically two answers. So the textbook, it says Arthur Chaskelson, but isn't it technically, is it Muhammad was the first one?
You are right. It was Chief Justice Ismail Mohammed. Give him a gift over there. They're still thinking about the public protector. I'll give to the first speaker from NPA. Over to you, ma'am.
Yes, no problem. No. This is fine. I'll try my best to stick to the 7-minute timeline. Good afternoon, everybody. We're at the afternoon session of this today. Certain all protocols have been observed, and I'm not going to take an extra minute to greet everyone. My name is Renee Ace. I graduated as Renee Prinsloo. I'm a career prosecutor. I started my prosecuting career in June, the 1st of June, 2007. And I started my career as an aspirant training prosecutor in Athlone Magistrates Court. I finished my degree at the University of the Western Cape in 2006, and I was unemployed from January 2007 up until June 2007 when I started the ATP program. It's important to note that all of you know what a prosecutor is, right? I made the decision early on at university that I wanted to be a prosecutor. It has become more popular over the years since I've become a prosecutor, but I can tell you this, when I told my friends at campus I want to be a prosecutor, their first thought was, what is that and why would you want to do that? My father, who was a school principal at the time, he retired now, said to me, you cannot do that. That is not what I signed you up for to study law for. I thought you were going to be in corporate, I thought you were going to be in an office, and that was the last thing that I wanted to do. Prosecution is a calling. I am a criminal litigant. However, when I was sitting and I was watching Justice Nuku sitting on the bench, I remembered that when I was in Standard 4, somebody asked me, what do you want to be one day? And I said, I want to be a judge. So let's bank that. That's there. So, as a prosecutor, I am employed by the National Prosecuting Service. I work for the state. I am a public servant, so I get the benefit of the increase every year. Great. So, the National Prosecuting Authority, next slide, please. Don't seem to be getting it right here. Thank you. Section 179 of the Constitution that we are celebrating 30 years of empowers us to institute prosecution. A lot of people think being a prosecutor is about getting a conviction. Being a prosecutor is about making a decision to prosecute. That is our core function. That is the most difficult decision we face every day. You have a complainant coming to you in the district court, more likely on a Monday than any other day of the week, with 2 blue eyes and telling you, you can see she was assaulted. Mevrou, ek wil nie meer aangaan met die saakie. I want to pull back my case. I want to withdraw. You, as a public servant, a young one, because I was 23 when I started, have to make a decision about, are you going to withdraw this case? Is it in the best interest of that complainant? So we serve victims. We deal with the most vulnerable people in society every day. By show of hands, who of you here have been affected by crime? Almost all of us. If it's your car that's broken into, if it's your house that's broken into, if you've seen somebody steal something, if you're a witness in a criminal case, we all have. Who represents us in court? Us, the prosecution. You don't appoint a lawyer to represent your case. The state appoints us. We represent you. And it's part of the Constitution. It's not that I'm taking these powers upon myself. It is mandated. It is the citizens' rights of this country to have a prosecutor representing them in court should they become a victim of crime. So our role is extremely crucial in the safety of the country's citizens and the rule of law being implemented daily. A prosecutor, by definition, is a litigant. So if you don't feel that you want to go to court and argue a case on behalf of somebody else, this is not necessarily the career for you. So that is who we are. Our core function is obviously to institute. Next slide, please. I work for the National Prosecuting Service. That is the business component of the NPA. So there are other people within the NPA who are not prosecutors, but those who work for the NPS are indeed prosecutors. My colleague Eric Ntabazazila, they are our communications guy. He works for the NPA, I work for the NPS. Next slide, please. And that, mind you, that lady on that picture, she was our director up until 2 months ago, and now she is the Deputy National Director of the NPS. So Western Cape breeds excellent prosecutors. Next slide, please. How do you become one of us? You obviously have to have an LLB, it goes without saying. You have to show independence, professionalism, accountability, and you must be able to be a credible person. You must participate in a 12-month program. You will do mock trials. You will actually go to court. There's only 1 month of theory. So as a graduate, when I started in 2007, there was this idea that you had to do legal aid first and become an attorney and get admitted and then become a prosecutor. It's not that way anymore. I went straight from university, or rather from unemployment, into prosecution. Next slide. So the ad was actually out 2 weeks ago, and the date has closed. You choose one training center. There are 2 training centers in the Western Cape. Sometimes there's more if they need more prosecutors. You do the program if you successfully complete the program. And it is a very rigorous program. Do not underestimate it. Firstly, you're thrown in the deep end. You do a month of theory. You go to court, and every month you meet with your tutor who provides you with a formal assessment on where you are lacking and where you need to improve and where you're showing good promise. Every month you get a report card. Some people who are on the program with me did not successfully complete the program. It is not guaranteed that you will be successful. The aim is to employ you and retain you. That is the aim of the program. But if you don't meet the minimum requirements or you don't perform adequately, unfortunately, some of you will not complete the program. Next slide, please. So there's a study guide that you get. You have to study it. Goes without saying, you guys are used to exams. It's 150 multiple choice questions. I know some subjects at university. When I was at UWC, criminal law was a lot of MCQs. It is torture. It is just as stuff said in the negative. You have to really analyze it. You need to know what you're doing. Once you do that, that's a 3-hour exam. A lot of people don't even complete. Once you succeed in that, you will be shortlisted for an interview. And there you really have to shine. And the questions will be on the law. Because we need to have a means to check what your capabilities are. Next slide. The program, I've already mentioned how it works, what is required of you, and it's really impactful. Next slide, please. And after you are done, there are certain expected outcomes, like I've said, and I know that as part of our assessment, we had to do a trial, complete, and your tutor, and we get outside people to come and assess you from head office, and they will make a call and say, suitable, not suitable. They know how to put the charges, they know how to complete the charge sheet, they know how to cross-examine. That is what the 12 months is for. Next slide, please. Career development in the NPA. So I told you guys I'm a state advocate. Next slide, please. We're not part of the Legal Practice Act. Next slide, please. So you start in the lower court. The lower court is what the Criminal Procedure Act refers to it as. That is your district court and your regional court. The regional court, you can obviously get life sentences as well. And then the high court. That is the steps. So you start as an aspirant prosecutor. I was an aspirant prosecutor. I was a district court prosecutor. I was posted in Malmesbury. Knew no one, had to move, had to go there. Then I became permanent immediately. Some people are not that fortunate. Some people go on contract first. Then you become a control prosecutor or a regional court prosecutor. Then you can either become a senior or you can move over to head office in the province. That is the DPP's office. That's where I work. You become a state advocate, hopefully a senior state advocate, and maybe a deputy director. But there are not that many, as you can see, as an organogram reflects. Next slide, please. Units within the NPA. I used to work for the Sexual Offences and Community Affairs Division. I am still passionate about that, and I still prosecute predominantly those offences. Organized crime component, those are my colleagues who drive around with bodyguards because they have to. The unit they work in specializes in this. Specialized commercial crime, also becoming just as dangerous, specialist unit. Priority crimes litigations unit, specialized tax unit, and obviously IDAC. Next slide, please. Civil law opportunities. People don't speak about this often because they think we only do criminal litigation. It's not all we do. State advocates at our office work in the asset forfeiture unit, and they've been extremely successful in seizing the proceeds of crime. Next slide, please. Legal Affairs Division, same thing. They sometimes represent us, and we don't have to pay outside advocates, to represent us when there are civil claims. Next slide, please. Thank you, everybody. So, I think you guys need to understand that when one walks into a courtroom, and you're representing somebody else, you carry their trauma on your shoulders every day. Never underestimate that. If you feel that that is not for you, don't apply to be a prosecutor. People have applied. I had a colleague once, she was an ATP after me, but she came from private, she worked at BP, British Petroleum at the time, and she said, I can't do this. This is not for me, I'm going back to the private sector. You deal with the most vulnerable people, but it's so rewarding when you can dispense some form of justice in winning your case and giving families peace. I was tasked with doing the case of my colleague, a private attorney who was murdering Kaelicha. That trial took me 3 years to conclude before the Honorable Judge Slingers. Judge Nuku, it was so difficult to do a matter of somebody who you knew, but somebody had to do it. Yes, only 3 of the 5 were convicted, and they got life sentence, but the point of the matter is difficult work. I recently got a conviction in a child pornography matter, or CSAM, child sexual abuse material, where the file was sent to our office for guidance. I asked the prosecutor, what is this? They sent me a flash drive. I was forced to watch it. I had to watch it. He went to prison. He was out on parole, went through a couple of children, made videos thereof, and ran away when he knew he was going to be arrested with a flash drive. The flash drive, the complainant who made the case was an older girl. So she was 17, and she said he took photos of me when he raped me. So the detective says, and to see what's on this flash drive, assuming it's that. No. Then we found other complainants. Then we traced those complainants. Then I got the life sentence for him. But is that enough? It's out there in the world. It's done. The secondary victimization every day. Is it enough? I'm not sure that it is. But always keep in mind, as future lawyers, because you are going to finish, that the safety of the people shall be the highest law. And I thank you.
Thank you very much. Can we hand over to Legal Aid South Africa?
Good afternoon, everyone. I think I did put a presentation there. Can you hear me? Okay. Okay. Good afternoon once again. All protocol observed. Thank you very much for giving me the opportunity to come and present to all of you. My name is Pumezo Khelile. I'm the Provincial HR Manager at Legal Aid South Africa. Okay. My role is just to give you an idea in terms of if you want to join Legal Aid South Africa, what processes you need to follow. Okay. First of all, I must just mention that Legal Aid South Africa, we regard ourselves as the biggest law firm in the country. We have offices everywhere within South Africa. When we recruit for candidate attorneys, we have the online recruitment, which we always encourage candidates to go to our website. We open our recruitment program in February, at the beginning of February, and we close at the end of March each year. So we encourage applicants to follow us in our social media platforms so that they can get first-hand notifications. Because remember, sometimes if you will wait for our advertisements without following us, sometimes you might find that you are aware of our advertisements when we are closing. So that's why we encourage that you follow us on Facebook, you follow us on LinkedIn, then you'll get the first-hand information when we advertise. Okay. When selecting placement, applicants need to select legal aid SA 6 provincial groupings. For example, what we have at legal aid is that we have provincial offices which have provincial heads. Eastern Cape is a provincial office on its own. Free State Northwest is combined with one provincial head. We have Gauteng, we have KwaZulu-Natal, Limpopo, Mpumalanga is combined with one provincial head, Northern Cape and Western Cape as well. So in terms of your application, you need to make sure that you select the correct province of your interest so that we can be able to allocate all the applications in that regard. Content. In terms of applicants, what they need to consider. We only accept applicants from LLB graduates. I think that has been the communication from all legal firms in here. Why we emphasize is that you find out that sometimes first-year students, second-year students do submit their applications, whereas you'll find out that if you don't have a LLB graduate, you will never be considered to do articles. So that's why we emphasize on that. Applicants need to attach their transcripts to their applications, meaning that from your first year to your last year, we look at the average of your courses that you have passed, and then we take an average of 60%. Why we're doing that is that we need to have a standard. Each and every organization has its own standard. Otherwise, if we don't have such a standard, it means that we'll have to now consider each and every person, especially with the fact that now we will not even have the capacity to do that. So we need to have a standard so that we can be able to start somewhere. So we accept one application per ID in order to prevent duplicate applications. What we have found in the past is that people will just apply, for an example, more than 2 times, maybe 3 times or 5 times, with the hope that if you apply a lot, your application will be considered. So that's why now we say each and every one ID application, you won't be able now to do that, because history also has told us that we look at the applications after the advertisement is closed. We find out that we have 1,000 applications. When we zoom in to look at those applications, we find out that actually we have 200 people that have applied. Others have just reapplied all the time, thinking that if you apply a lot, your application will be considered. So applicants do not need to have completed PLT. You can do your PLT while we are working within legal aid, or you are doing your articles. It is not compulsory for candidate attorneys to have a driver's license. So sometimes when I go to universities, people always ask me, do you have to have a driver's license to apply? So no. So you just apply to be a candidate attorney. Yes, to have a license is a privilege for you, so that you can be able to drive our cars when you have to go to court. Otherwise, it's not a prerequisite. Once you submit an application, you cannot apply again in the same period or amend your application, meaning that after you have done your application at that time, make sure that when you submit, you've checked out everything, because after you have now submitted your application, you won't have the opportunity to amend again. Okay. Yes. Placement. Applicants who meet the requirements are invited to write an online assessment, meaning that after the closing date has now passed, we look at all the applications, and then we shortlist based on our criteria, 60%, LLB, etc. So applicants who meet the requirements are invited to write an online assessment. For example, we will, at once, maybe we'll invite 100 people to come and do our online assessment. So applicants who pass the assessments are invited to interviews. Well, another thing that we notice is that applicants do apply, and then when they are invited to come and write assessments, they don't pitch up, you know. So what I'm trying to emphasize is that if you want your career to be noted, or if you are serious about taking your career seriously, you need to make sure that when you apply, you follow through. You don't get invited and then you ignore it. Those are the small things that you need to make sure that when you start in your profession, you start with that kind of a seriousness, taking yourself very seriously. So candidates who pass the interviews are invited for, after you pass your assessment, then you are invited for interviews. And those who have passed the interviews are invited for background checks. And if you are successful, they are placed in a pool of candidates. What we do at Legal Aid is that we use what we do push system. We don't wait for positions to be available. So we don't wait for positions to be vacant, then we start recruiting. While we are doing while we advertise our positions, we make sure that those people that are successful are put what we call a pool of candidates, so that when the vacancy arises in one of the offices, then we call you to say, look, are you interested to work in Bellville? There's a position working in Bellville. Then if you are interested, then we place you there. Otherwise, if now we wait for Bellville office to have a vacancy, we start recruiting, we'll be delaying the course. Okay, Legal Aid South Africa offers a 2-year contract of articles. So we have 2 years of articles with us when you are employed. Also, the CA also signed a contract with Legal Practice Council. I think Legal Practice Council has also said as such. We offer an attractive remuneration package of 8,000 Rand in the first 2 months, because in the first 2 months you are still busy with your induction, with your administration in terms of your onboarding into the organization. And then after 2 months, we pay you 21,000, which is a lot of money. It's a lot of money for someone who just started. For the purpose of PLT, Legal Aid SA allows a maximum of 25 working days. Okay. Just to add, at Legal Aid South Africa, we value our employees. We have been the employer of choice for the past 18 years, and I've been there over 10 years in the organization. When I started, I thought I was going to leave within 2 years, but because of the manner in which the organization treats its own people, we stay. And you'll find out that 70% of the employees in that organization have more than 10 years because of the manner in which the organization treats its employees. Thank you very much.
Thank you very much. The next speaker from the Office of the Public Protector. Over to you, sir. I like that you are timing yourself.
Special greetings to the Program Director, our distinguished guest, Justice Nuku, and the Deputy Minister of Justice, and our acting dean, Professor Pienaar, and to all the members of the legal profession who are here today, and also to all the law students who are here. I'm really, really honored to be part of the people who are invited on this career exhibition. I'm not sure if I'm loud enough, my ear is slightly blocked. Yeah, so my name is Sisa Magele. I'm the acting provincial manager in the Western Cape of the Public Protector. I've been acting for almost a year now, part of the investigation team. I'm a senior investigator responsible for special project. That's what I do. I'm just an acting manager at the moment. I've started working for this institution as an intern in 2013, just after I completed my law school at UCT in June 2013. So I completed my LLB at UWC in 2012. Thereafter, I went straight to law school. So I've been with the institution for almost 13 years, if I'm not mistaken. So mine is just to share with you what we do as the Office of the Public Protector and to inspire you to join us. And then I don't want you to join us under the impression that this is what you wanted, only to find out it's not what you are really in for. So I will share with you some of the work that I've started doing while I was working as an intern up until I was promoted from assistant investigator, up to senior investigator. So I think, in a nutshell, what is the public protector? As Professor Madlingozi alluded earlier on, we are one of the Chapter 9 institutions that are established in terms of Section 181 of the Constitution, along with the Human Rights Commission and the Commission for Gender and Equality. So our purpose is to strengthen and promote constitutional democracy. We do so through holding those who are entrusted with public power accountable. What do I mean by that? When our elected representatives, such as the politicians, are no longer fulfilling their constitutional obligations, when they are corrupt, they are no longer serving the interests of the people. It is a task of the public protector to hold them accountable through the investigative work that we do as an institution. So we derive our mandate from Section 182 of the Constitution, together with all other pieces of legislation that confers powers to the public protector. So the Constitution gives us the power to investigate any maladministration, improper conduct in government departments, in all spheres of government, including public administration, and all organs of state, as defined in Section 239 of the Constitution. And we also have the power in terms of our enabling legislation, which is the Public Protectors Act. That is a primary legislation that gives us our investigative powers, give us the power to investigate almost everything in state affairs. Improper conduct, maladministration, undue delay, irregular appointment, nepotism, irregular award of tenders. So those are all functions that are listed under the Public Protectors Act that we have a right to investigate. It's too many things, to be honest. We are also the sole institution that has the power to investigate cabinet members for violation of the Code of Ethics. You will note your Pala reports, your Zwile Teats, those are all reports emanating straight from our Executive Members Ethics Act. So we have that power. And in terms of that legislation, only cabinet members can lodge a complaint. No ordinary member of the public can lodge a complaint against a member of the cabinet. And then we're also a safe haven for whistleblowers in terms of the Protected Disclosures Act. People who want to blow the whistle about any corruption that is happening in government departments, in universities, where you are also an employee. So we have the obligation to protect you against occupational detriment after having lodged all those complaints. And then we are also part of, there's quite a lot of things, to be honest, but I just want to share with you what is it that we do as an institution. Not necessarily the legislative and other things. When you come in as an intern, you'll be introduced to screening and assessment. You'll be doing consultation with new complainants. We don't take instructions from client. We consult with them, because taking instructions, it means that you are representing them. So we don't represent members of the public who are coming to our office to lodge complaints. We still have to be a neutral, impartial body that is independent, acting without fear, favor, or prejudice. So those are the principles from the Constitution governing the work that we do and how we must conduct ourselves as investigators. What does this mean? A complainant needs not to come to the office of the public protector with a fully made up case. It is us that who have the obligation to investigate those things. But it does not mean that you must come to us with a frivolous complaint, vexatious complaint, something that is unfounded. So the onus of proof, at least there must be a prima facie case. There must be a likelihood that a legally protected right of a member of the public has been infringed. So it's quite a very, very easy standard to meet, because everyone can come to us to lodge complaint. We're a very popular institution out there. We're trusted force by the people of this country. So if you are really looking forward to make a difference in the lives of ordinary people, to serve humanity, to be at the center of accountability, I think the public protector is the right institution for you. If you have empathy and passion for research and human rights, you have empathy, you have passion in administrative law, because most of the work that we do is purely administrative investigation. So you'll be exposed to administrative law, constitutional law, public procurement. You will need to understand a little bit of labor law because you'll be dealing mostly with irregular appointment complaints and also your bread and butter complaints. Those will be your social, economic complaints relating to SASA, grants, home affairs, undue delay to issue IDs, housing issues, undue delay to allocate housing, irregular award of houses, and all those things. So those are mostly the complaints that we deal with at the office. And one of the mechanisms that we adopt or we use to resolve complaints is alternative dispute resolution mechanism. Your negotiations, mediation, and negotiation. So by virtue of being appointed as an investigator, you're automatically an alternative dispute resolution officer, meaning that you can use all those mechanisms out there as part of resolving complaints. But as part of our mainstream program, we're a very small organization, just like the Human Rights Commission. So we only absorb people through our internship programs that are often advertised at the very end in December of each and every year. They run for a period of 2 years. But the PP, the current public protector, is also busy with the project, but it's still at its infant phases of having an academy, just like the NPA, where you start off as an assistant investigator through that graduate program. Thereafter, we can absorb you as a junior investigator up until you grow within the organization as an investigator. But we also have a legal service component. That is our legal service division that assists us with defending our reports in court. But they don't represent us but they do brief advocates or instruct attorneys to defend our reports. So that is the legal service unit. We also have internship each and every year for that division. So it's only 2 divisions that are really accommodate your students. It's our core, which is investigation, and the second one is our legal service unit. So if you are really looking forward to bring about social changes in the lives of ordinary people through the application of the law, this institution will present that perfect opportunity for you. We all understand that access to justice remains a major challenge in these countries. The traditional check and balance mechanisms are not adequate to ensure that everyone has access to justice. And the cost of litigation is very, very expensive. Even us as an institution, we can't afford to defend almost all our reports. Some of them, we just don't pitch up in court, and then they are set aside. So for you to be an alternative or to play a part in helping the South Africans, or majority of our people, to have access to justice, I will suggest the Office of the Public Protector. You just have to love research. We're dealing with a lot of data, so you'll be analyzing a lot of data as an investigator. The majority of the work, you do it by yourself, including your legal research. Our legal research unit come at the very tail end of the investigation. So you'll be doing everything by yourself up until the finalization of the investigation and adjudication. Thank you.
Thank you. Next speaker, Mr. Makubela. Mr. Mukuluvet, I will indicate when you are left with 2 minutes. We want to open it up for questions before our learner transport leaves. Thank you.
Thank you very much, Program Director. Unlike me, I'm going to be stopped when time is up. But that's fine, because obviously I know that we must be tired. There's a lot of information that has been given to us since this morning. And yeah, indeed, it's understandable that there must be some timing of what presentations we are giving. Good afternoon, everybody, and the Deputy Minister. My name is Makubela Mukudubete. I'm a Senior State Law Advisor in the Department of Justice and Constitutional Development. I must indicate how lucky you are, because the information that you are being given today, not all of us as lawyers were being given. As a legislative drafter myself, I only knew when I was in practice that I do qualify to become a legislative drafter. So now, I started where you are. I also was a law student. I studied at Natal Varsity. I did BA, LLB, and LLM. And I'm also an admitted attorney, and hence I qualified to become a state law advisor in the department. And this department has got a branch called Legislative Development and Legal Services. It has got several chief directorates, which is a Chief Directorate Legislative Development. There's a law reform, a South African Law Reform Commission. I'm sure you are aware of it. There's also the Rules Board for Courts of Law. There's also the Chief Directorate Legal Services. If we can go to the next slide. Am I able to change this? Yeah. The Legislative Development and Implementation, that is the branch or the Chief Directorate that I'm in. It is the branch or the Chief Directorate that drafts the Acts of Parliament for the Department of Justice and Constitutional Development, and also the regulations that must accompany the piece of legislation that we come up with. I must indicate that in his remarks, opening remarks, the Deputy Minister made a reference to an Act of Parliament that I drafted myself, which is the Cannabis for Private Purposes Act. And I had some giggles when the minister said that, so I wondered why. But that's beside the point. What I'm getting at is that it's one of the pieces of legislation that I drafted myself. It has been finalized, and it has not come into operation because it awaits the finalization of the regulations that we have drafted, and we published them in February for inputs by the 5th of March. I hope you as aspirant lawyers will have given, have you submitted your comments on the Cannabis for Private Purposes regulations? No. Well, that's fine. So that's the primary legislation, the Cannabis Act, and the secondary legislation that we draft is the regulations that we are finalizing now, as the Deputy Minister has mentioned. And we also provide the advice to the Minister, the Deputy Minister, and the Director General on matters of legislative nature. We are not only confined to drafting legislation, we also do advice. We also bring into operation the new or amending legislation. The Cannabis for Private Purposes Act is a new piece of legislation that was drafted by us, and there are amending acts. I'm sure you will have heard of the Domestic Violence Amendment Act that was promoted by us because of the situation that was happening during the COVID-19, and that is one of the amending legislation that we have prepared as the department. We also do the workshops, we do seminars, conferences. Professor Madlingozi was here. He once invited us to have a conference for the Rastafari, representative of the Rastafari groupings, because as you know, they have interest in relation to cannabis. And as the drafters of the Act, the South African Human Rights Commission did invite us to be there. So we do that, and we do also the legislative program. We do run that. And then those are the posts that are available to us. And I'm raising this because it is the unit that I'm working at, the legislative development. And then there's a South African Law Reform Commission. The South African Law Reform Commission, it has also got a posts that are available for law students. But unfortunately, you have to be admitted as an attorney in order to qualify for those. Lucky for you, you don't have to be in practice, because when I joined the Rules Board for Courts of Law, it's on the next slide, the next one. The Rules Board for Courts of Law, it's the Chief Directorate that develops the rules of courts. I'm sure you have a civil procedure that you are being taught at varsity. The civil procedure that you are learning, this is the unit that is drafting the rules. So if you join the department and being able to qualify for this, you will be drafting those rules yourselves. There's also the unit legal services that deals with litigation in collaboration with the state attorneys. So I will want to go to the second last slide. That will be slide 8, I think. If you can go next slide. I want to talk quickly about the caliber of legislative drafters. As I've mentioned, you have to be admitted, and then you need to have a broader knowledge of the law. You also have to have research skills. You need to know the Constitution and other piece of legislation that could be related to the law that you will be working on. You must be able to work under pressure, because there are projects or piece of legislation that requires to be dealt with on an urgent basis. Like I made an example of the Domestic Violence Amendment Act. There was an urgency during COVID, domestic violence occurring, and we had to come up with amendments to the act so as to curb the incidents of domestic violence that were rife at that time. You also need to have drafting skills. That's very important. Luckily, there are universities that are providing that legislative drafting course. When I joined, there was no varsity, or there was no legislative drafting course that was provided, but within the department we have a justice college that provides a training. So this is one of the training programs that we have that is provided by the justice college. You need a presentation skills. You need to be willing to work extended hours. Over the weekends we do work, but it doesn't mean you're going to be working every weekend. So rest assured that this does not happen frequently, but it does happen. And when it does happen, you have to be able to do that. And then the willingness to travel, because there are projects that will require you to go to different places, and you should be able to do that. Just by way of a closing, then we have the internships that are available within the department. We have graduates that are placed within those chief directorates, the 4 of them. They are working on a rotational basis, a period of 1 year. So it means we'll have 4 law graduates who will be placed in one of each of those 4 chief directorates, and then they will each circulate so that everyone can be able to have an opportunity to learn what each of the chief directorates is working on. So that brings me to the conclusion of my presentation, and I wish you all the best, and thank you very much.
Thank you very much, Tate Mkulubete. We're going to open it up for questions by show of hands. There's one there. Can I have people are roving us? 1, 2, 3, Is it you? Are you? Okay. There's only 3, 4. Are you not number 2? Why are you raising many times? It's 1, 2, 3, 4. Okay. In that order. Remember, you introduce yourself, the institution, and you ask a question, and direct it to any. Remember, we also had law firms, no?
Thank you so much. Good afternoon, everyone. My name is Sengosi Nugu. I am a third-year LLB student, and my question is towards, I think it's Advocate Renee from the NPA, if I'm not mistaken. Is that me? Oh. So, I'm sure you've seen the Joe Sibanyoni case that happened a month or so ago, where it was about extortion, the 2.2 million rand extortion case, where essentially the prosecutor was a no-show at the day of the hearing, and ultimately Joe Sibanyoni's attorneys argued for the case to be struck off the roll. I just wanted to ask, out of curiosity, have you ever seen something like that in your career? And if you have, what are the consequences for that particular prosecutor for not showing up? Thank you.
Over to you, sir. You can stand. Over to you.
Hello, my name is Pienaar, a first-year LLB student. I have a question for Mr. Makubela. I forgot the name of the bill itself, but it's related to drug and tobacco control, related to just new regulations regarding restricting smoking. And I believe they're trying to as well include vaping as well within that bill. So my question is specifically, doesn't there have to be some form of like consultation with the public on bills such as that, which will directly affect? Because at the moment, although smoking is considered somewhat restricted by law within doors, e-cigarettes are not a bit more, it's a bit more of a gray area. So I'm just be curious as to, has the government been considering that aspect of it? Thank you.
Hello, my name is Niogi Josiani from Rosebank International. And my question is, given the strict rules around citizenship and court admissions, what does the professional pathway look like at legal aid for international graduates who want to complete their contracts at your organization?
Good afternoon, everyone. My name is Nkosi from Stellenbosch University, and my question is directed to Mr. Masela from the Office of the Public Protector. My question is, how does the office, since we're celebrating 30 years since the adoption of the Constitution, how does the Office of the Public Protector ensure that constitutional accountability becomes a practical reality to ordinary people rather than just producing reports and legal findings?
There was no other hand, right? Oh, this is the last, fourth one. Over to you, ma'am.
Hello, I'm Devondre Andreas. I'm a BCom law student in my second year now. I have a question for Ms. Renee. So personally, I want to specialize in criminal defense. But this is a question that I have. As a prosecutor, how does one often deal with traumatic cases, keep your moral compass intact, and still be emotionally intelligent, not to get caught up in the process? And then the follow-up question is, what would you say is one habit or personality or characteristic that you think that criminal defense attorneys should maybe adjust or maybe adapt? Thank you. Adopt. Thank you.
Adopt, adjust. Yes, you may proceed. I think those are all the questions that were asked. Maybe let me start with the NPA.
So I have two questions, but I choose to answer hers first because she's asking me from the perspective of defense, which is very interesting. My first advice to any defense counsel, if I'm in trouble with them, is make admissions. That would be my advice. But with regard to trauma, and we have debriefing sessions within the NPA, and I'm certain my colleagues at the Legal Aid Board do the same as well. But you need to leave the emotional trauma in the courtroom, because if you don't, you won't cope. So you need to take that haversack off as you exit and go home and be a normal human being. Also, we have to remember, in the criminal justice system, we are dealing with criminals. Not everyone is a criminal. Until they're convicted, obviously, Judge, I understand that part. But as a prosecutor, we are not dealing, everybody is not a criminal. That would be the wrong assumption to make. And so that's why it's easy to leave it at the door, because you know that not everyone is a criminal. These are people, based on circumstances sometimes, based on what economic reasons. I'm not judging them for doing what they did, but I'm not a judge, I'm a prosecutor. But the position and the way that things work is you need to leave it at the door. You can't take it home with you. That's the first thing. And the second part of the question? Well, I think for anybody working in the criminal justice system, let alone prosecution defense, is you need to adopt a real sense of bravery. Because you're speaking for those who can't speak for themselves, whether it's a complainant or whether it's an accused. Not all accused are guilty, believe it or not. So you need to be brave, because you are a representative of someone who can't speak for themselves, and that is probably the most important step that you need to take is, I'm standing here on behalf of somebody else, and in the criminal justice system, the chances of you going home is guaranteed, but not necessarily for your client. So you need to be brave. You need to be brave, and you need to give it your all. That's what you need to do. But pertaining to the prosecutor where the case was struck off the roll, that was a very unfortunate incident. There was inquiries done by National Office. He wasn't not available, he was in fact absent, which is an unusual circumstance, because my colleagues who work in criminal litigation and in the criminal courts will know that you shoot one prosecutor, another one pops up. We like those dolls that just bounce up. There will be somebody else to take over. So you're not really going to gain anything by getting rid of any one of us. His reasons for his absenteeism was fear. His life had in fact been threatened. And that was the reasons for the absence. Disciplinary proceedings have commenced. I'm not privy to that. I'm way below that in my pay grade. But yes, ordinarily, a prosecutor is never absent. Because if I'm not there, one of my colleagues will be there. So that's the normal course of events. But we don't know the threat and the extent thereof. So we don't know if the colleague said, I'm sorry, not my business, I'm not going to go. But I do believe the matter was also re-enrolled. So a case is never done if it's withdrawn or struck off the roll. Remember our powers that I spoke of earlier, the NPA? We institute criminal prosecution. So we institute again. Who's next?
Thank you very much. The question by the gentleman there, when in 2018, in December 2018, September actually, the Constitutional Court declared certain sections of the Drugs and Drug Trafficking Act unconstitutional, and it ordered Parliament to rectify the sections, and the option that we took was to come up with a stand-alone piece of legislation, being the Cannabis for Private Purposes Act. So now, the Constitutional Court, when it handed a judgment in September 2018, it said Parliament must draft a legislation that will allow or permit adults to use, possess, and cultivate cannabis in their private spaces. Now, we came up with this a piece of legislation, and because the keyword is in private, you cannot just be walking around on the street smoking cannabis, because you'll be locked up. You can't. It must be in your private space, because the Constitutional Court said that's what we must do. Now, You must be aware also that this is confined to adults only. So if you are not an adult, you cannot legally use cannabis. However, if you are caught using cannabis as a young person who's not an adult, you cannot be dealt with through the criminal justice system. There's a constitutional court judgment in the Center for Law, Center for Child Law, a judgment that said if a child is in contravention of cannabis-related legislation, that child should not be dealt with through the criminal justice system, but they must be dealt with through the civil justice system. So we are not going to have the police looking away the children because they use cannabis. They are going to be processed differently through the civil justice system. So you can't, as an adult, as a young person, you can't use cannabis, and as an adult, you can't smoke it in public. We are consulting each and every piece of legislation that must be promoted, must be consulted upon. That is why we publish, inviting the public to comment on the piece of legislation first, and also the regulations. That's why I mentioned that we published in February the cannabis regulations to invite the public to comment. So if you have a comment on a piece of legislation, then you are by all means free to give your inputs. But each and every legislation that is going to be promoted must be published to invite the public to comment. Thank you very much.
You can proceed, sir.
Okay, on the question from the, can you hear me? On the question from the gentleman out back there, how do we ensure that this whole constitutional dream becomes a reality? We don't just publish reports after reports. You will note that the Constitutional Court in 2016 pronounced on the legal effect of the remedial action of the public protector, that it is binding against those who we've made findings against. And you will note back then there was a pushback from the president indicating that he is not bound to comply with our recommendation because they were merely recommendations. So since that judgment, the implementation rate of our remedial action have gradually improved. We still have challenges with the implementation of remedial action. There's quite a lot of institutions that are not complying with our remedial action despite that Constitutional Court judgment. So recently, through our legal service division, we've made a lot of submissions to Parliament for legislative reforms in our Public Protectors Act, which is our legislation, to make it a criminal offense for any accounting office of an institution not to comply with remedial action in the absence of judicial review. So we are trying to get Parliament to assist us in that process. Thank you.
Thank you. We'll take the last response from yourself, sir.
Hello, can you hear? Okay. In terms of international students, we do consider requests if they are done by the institutions to say this is a student that needs experiential training. We consider that, but it's not remunerated. It's just an experiential training or job shadowing. In terms of articles itself, articles are given to South African students or graduates. Thank you.
Thank you very much. I think we have come to the end of our program, and I would like to thank everyone for their participation. Deputy Minister Andries Nel, thank you. Thank you so much also Justice Nuku for staying throughout, and we'll also thanking the leadership of the institution, the acting dean in absentia, and Prof Thuli Madonsela. The legal firms that participated, thank you very much. The legal professional bodies from the Cape Bar and the LPC, thank you very much. The law firms, Bomens in absentia as well, thank you very much, Nkotla, thank you very much, ENS. And to the students, we hope that this session was beneficial to you. The contacts are at the back, and I know that you also interacted and networked and you took the important details. Since we started with the career days, just to inform you, we have managed to over the years, we still need to quantify, but we get a lot of testimonials where people are saying they got placement in terms of their articles, their job shadowings, and I know most of them are done also in the offices of the state attorney in the Department of Justice. So I think this program is really working for yourselves, and it's an eye-opener. Without wasting time, transport is here. There's pre-packed lunch. You can just grab and move to your transport. I hope I also did justice. Thank you to myself as well as the program facilitator. We are closing the session, colleagues. The Constitution at 30, preserving Nelson Mandela's legacy of equality and justice, which is taking place as we are commemorating 30th anniversary of the country's constitution. Remember, we are reflecting, renewing, and recommitting. All the best on your future endeavors, and thank you. To our stakeholders, where you were, there's refreshments.